Delivery of order item number 1.
For reasons mentioned in the order, the prayer for bail of both the petitioners is rejected. Hello.
In item number 32, I have filed a bail objection yesterday. The same may be called for and brought to my court.
Okay.
I have
Item number 32. Yes.
I have filed an additional affidavit, my lord. That may be tagged with item number 61, my lord. Long back I have filed.
All the additional evidence.
In prayer, my lord.
Item number
Item number 60. Motion.
60. Additional evidence.
Problem.
Yes, be quick.
So I beg to mention for listing loss. For last two months.
For hearing column or which under NDPS matter?
No, POXO.
POXO. 5th of August.
Also, I beg to mention item number 64, my lord, from supplementary list. 64. It is available here, my lord. It's available. But this item may not be reached today, my lord.
So you want
Next week, any date, my lord.
No, we'll wait. If it does not reach, we will give dates. Not now.
Maybe the Lordship, I beg to mention item number 22, my lord. Well, case there is not available.
22. Learned additional public prosecutor Mr. K.K. Parashar praised for some more time for producing the case diary. You are on interim.
Yes, my lord.
Learned counsel, Mr. What is your name?
B. Saikya, my lord.
Mr. B. Saikya, learned counsel for the petitioner, submits that the petitioner is on interim bail. Stop. Let this case be listed again on 21 August. The interim order shall continue till next day.
What's it?
In item 43, I am an interim for the, so for the record concern, this charge sheet is left. Item 43, Lordship. 43. 43.
Yes. What is your prayer? Have you appeared before the IO?
Yes, Lordship. I am getting interim. I got the before the IO, Lordship.
Mr. D. De, learned counsel for the petitioner, also Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
65/2025, dated 204/25.
Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court by order dated
040825.
25, and he has cooperated with the investigating officer in pursuant to the directions of this court. Considering the submissions made by learned counsel for the petitioner, the interim bail granted to the petitioner by order dated 048.
0408.
Repeat the date.
Yes, 0804. 0804.
8th April. 8th April 2024 is hereby made absolute.
May I please, your Lordship? I would like to mention for listing of a bail application, Lordship.
When have you filed?
Lordship, last it was posting on 11. Last date was 11/6/2025. Already scan copy and
NDPS matter.
yes, Your Lord.
5th of August.
Kindly 30 within 30.
No, it is not possible. It is 14th of August. You choose amongst 5th of August or 14th of August.
Means, first August Lordship, kindly.
Registry to fix the date. Your prayer is rejected. If you insist, I am giving date after considering my board. So you should not insist on date. Registry to fix the date.
Kindly let me fix the list.
No, registry will be fixing date. You pray, go and pray before registry.
Same order.
Ne-
Lordship, one more bail application.
When have you filed?
Already, Lordship, last date was, last posting was 24/6.
5th of August. 5th of August.
What the 5th of August, Lordship?
Okay.
5th. May please if you Lordship, Lordship, I would like to mention for listing of bail application.
Yes. 6th of August.
Lordship, one more prayer, Lordship, for withdrawal on Monday, Lordship.
Okay. Okay.
Nice. May please, Lordship, I'd like to mention for listing.
When have you filed?
Last date was 6 July.
7th of August.
I'd like to mention, okay, DA Lordship, filed on 16/5/2025.
For hearing column,
Hearing Lordship. It fixed on Tuesday Lordship,
7th of August.
31st.
7th, or you have to go after. Yes. Use microphone.
Lordship, I'd like to mention in DA for listing, for motion,
When have you filed?
before vacation,
Before vacation.
6/6/2025.
It has not yet been listed.
Listed on 18th. Last listed on 18/6.
For motion, Tuesday.
Please, Lordship, I beg to mention for listing on regular bail application, Lordship.
When-
Date fixed for bail hearing, but not listed, Lordship.
First of August.
Lordship, 52 days in custody, Lordship.
What do you want?
Lordship, 28.
Go and pray before registry. Pray before registry.
May please your lordship. I pray to mention for listing of criminal petition 900/2025.
Before senior court.
May it please your lordship. Lordship, I beg to mention for listing of a bail application. Lordship, this matter was last listed on 18 July, but due to paucity of time, the matter was not.
What is the matter?
Lordship, it is NDPS matter, Lordship. Only intermediate quantity was recovered from the petitioner. And as on date, 3 months, 22 days, he is on custody. Lordship, on next week, let the matter come, Lordship.
7th of August.
Lordship, next week, Lordship.
No.
Obliged, Lordship.
May I please, Lordship? For listing, my lord, old case, my lord, BR number 520 up to the 25, my lord. Last listed on the 30 April 2025, my lord, till since that day, my lord, has not listed in the.
NDPS matter.
Yes,
2nd of August.
obliged.
My lord,
4th,
That is it.
4th of August.
Obliged.
Your Lordship, I beg to mention item number 57. Lordship, case diary is not yet available. I pray for an adjournment before your Lordship with an extension of the interim model.
Heard Miss
Borgohain.
M. Borgohain, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. When? (21/8). The interim order shall continue till next day.
May I please, Lordship? Lordship, I'm mentioning on behalf of my senior S. Borgoy, Lordship, item number 59, Lordship. Lordship, my short prayer is that, Lordship, if this matter can be taken at 2 o'clock.
No, you wait for your turn.
Lordship. Lordship.
Lordship for withdrawal tomorrow, one bail application.
Okay.
I'm seeking listing, your lordship, it was earlier, taken bail application earlier, it was.
When have you filed?
2/6/2025. It was supposed to.
It
be
is
listed after-
NDPS matter,
No, no, POCSO, your lordship.
POCSO, pending trial,
Pending trial.
4th of August.
May I please, your lordship, I want to withdraw the item number 17, my lord. 17, 17.
Heard Mr.
F.A. Hassan on behalf of SC.
F.A. Hassan submitting on behalf of
F.A. H.C. Vishwas.
S.C. Bishwas. Praying, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This anticipatory bail is dismissed on withdrawal. This is item number 17.
17.
But in item number 17, neither your name is there nor Mr.
That is on behalf of SC Vishwas. my lord.
S.C. Bishwas' name is also not there. But you are engaged in the,
Yes.
you are engaged counsel.
Yes,
Your name is not reflected in the,
but I would agree, but I filed it.
no, are you engaged in this case?
Party has engaged me.
Your name is not there.
Probably it is, but my signature was like, my signature is there.
It is there.
Yes.
Okay, okay. Allowed. Withdrawal allowed.
Wait, this is a lordship. Lordship, I am praying for listing of one AB for orders, my lord. After perusal of the CD, it has come to notice, my lord, that POCSO has been added, my lord. So we have filed it amended cost title, my lord, by adding the section and making the informant as party, my lord. So this may be listed, my lord, for orders, my lord, so that we can take steps, my lord.
When? Tuesday?
Tuesday, my lord.
Tuesday.
I'm deeply aware.
Item 2. May I please, your lordship. Here was I, lordship. I have for correction of the name of the petitioner number 2, lordship. In
This is motion.
Some bail application, lordship.
Mr. What is your name?
B. Borgohai, lordship.
B. Borgohai, learned counsel in I eligible. Learned counsel for the petitioner. This interlocutory application has been filed by the petitioner in BA case number 2285/2025. Praying for correction of a typographical error in the name of the petitioner number 2 in the cost title of the anticipatory bail application, in the cost title of the bail application. The considering the submissions made by learned counsel as well as grounds for seeking correction of the name of the petitioner number 2, the prayer is allowed. The petitioner shall file a corrected cost title. You file a corrected cost title in BA number 2285 on Monday.
Today itself.
Okay, during the course of the day.
Sure.
List this matter again on Monday. You file it during the course of the day. It will be listed again on 28th,
Monday, lordship.
Monday.
Much obliged.
The IA is disposed of.
Much obliged. Item 2.
May I please, lordships. This is, my lord, a 483 petition, my lord. In this case, my lord, allegation is that, my lord, this present petitioner, my lord, is the chairperson of a, my lord, cooperative society, my lord, namely Unnati Trading Cooperative Society Limited, my lord, situated at, my lord, Khetri, my lord. in the district of Kamrup Metro.
When were you arrested?
My lord, I was arrested on, my lord, actually picked up 23/6/2025, my lord. Adjourned today, my lord, say 33 days, my lord, behind the bar, my lord.
Why your prayer was rejected?
My lord, the prayer was rejected, my lord, kindly have a look at page, my lord, 17. That is my lord, reject order.
Kesari,
Basically, my lord,
what is your name?
S. Ahmed, my lord.
No, the name of the
The
petition.
petitioner, my lord, Jitumuni Kolitan.
Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, call for the case diary
12.
on 12th of August.
My lord, only 33 days, my lord, and all the materials, my lord, whatever, my lord, in the were
Shorter date,
shorter, my lord, shorter than 7.
7th of August.
This month.
No,
Last.
it may not be possible.
My lord, then, my lord, I have a very simple, my lord, pardon. My lord, on my lord, 3rd of August, my lord. So,
You want it on Sunday?
my lord, my lord, this list is out with me.
Let
my
it
lord.
be on 7th of August.
Obliged, my lord, much obliged.
Regular bail application, my lord, as on today, 24 days. Allegation is that, my lord, from my possessions, beef was recovered, my lord. FIR is the page number.
How much?
As per the FIR, 21 kilo, my lord,
What is the date of your arrest?
27, my lord.
How many days you are behind it?
24 days, as on today, my lord, from the, on 27, my lord. Forwarding is that page number, my lord. Page number 16, my lord, and I am now in judicial custody.
You cannot sell beef within 5 kilometers of,
I have a stock, my lord.
but
that a
is it within 5 kilometers of?
My instruction, there is no temple within the.
Yeah.
I mean, judicial custody, we consider the 24 days already.
Heard Mr. M. Heard Mr. What is your name?
MAI Hussain.
MAI Hussain, learned counsel for the petitioner. Yes, Mr. No, we are allowing him. Counsel.
Then lordship on 28.
We are disposing of this bill.
I am calling for the CD,
Oh.
insist on calling for CD, lord.
Also Mr. K.K. Das, learned counsel for the petitioner. This application under section 483 of BNSS has been filed by the petitioner, namely Karim Ali, who has been detained behind the bars since 2/7/2025, within bracket for last 23 days, in connection with Mangaldoi PS case number 129/2025 under section 196 within bracket 1 within bracket small b /299 of BNS, read with section 13(1) of Assam Cattle Preservation Act 2023. The next para. The gist of accusation in this case is that on 1st of July 2025, one Ulendro Malia, SI of police, had lodged an FIR before the officer in charge of Mangaldoi police station, inter alia alleging that on receipt of an information through reliable sources that in a shop owned by the present petitioner, the illegal slaughter of cattle and selling of beef meat in contravention of the provisions of Assam Cattle Preservation Act is going on, a search operation was conducted, and during search operation, 21.57 kgs of suspected beef meat was recovered. Learned counsel for the petitioner has submitted that. Where is your authority? You said that you have been authorized.
The license, but I have a license issued by the town council.
So where have you kept that license? If you have not brought it, then produce that. We'll wait for that. If you make a submission before the court, there must be something to substantiate.
Police before the police, my lord.
Learned counsel for the petitioner has submitted that the petitioner has not contravened the provisions of Assam Cattle Preservation Act, and he has the authority to sell beef. However, he could not annex the said license along with the bail application. Learned counsel for the petitioner further submits that the petitioner has been detained behind the bars for last 23 days, and considering the period of detention, he may be allowed to go on bail. The learned additional public prosecutor, on the other hand, opposes the grant of bail to the petitioner at this stage and prays for calling of the case diary. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record. Stop. See, it is apparent from the available materials that the suspected beef meat has already been seized, and it also appears that the petitioner has been detained behind the bars for last 23 days, which in the considered opinion of this court is sufficient period to subject the petitioner to any custodial interrogation in cases of such nature. Stop. This court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of Mongoldoy PS case number 129/2025. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate Mongoldoy, Dorong Mongoldoy, with following conditions. 1 and 2. This bail application is accordingly disposed of.
Hello. Item 5.
No, 58 days behind the bar, statutory period is 60 days. Case is not yet charge sheeted, no FSL was filed.
What is the offense?
Offense, there is allegation of recovery of 62.5 grams, 6 grams suspected heroin.
62. You find out whether charge sheet has been laid or not. We'll fix it on Tuesday.
At that time, statutory period will be over.
Then you will be released.
My petition will be pending here. I will not be released there.
Then you may.
Excel, can take control. It's 2 p.m.
No, the amount of heroin seized is not, though it is intermediate, but 62 gram is not a very small amount.
maximum under commercial ground, it is under
They can detain.
250 above is the commercial.
When can you find out?
Today it's about tomorrow. Tomorrow.
Sorry, my lordship, only
58 on Monday.
the lordship.
Monday also,
Monday.
but statutory period will be over.
On Monday.
If by then
Well,
charge,
if your lordship grant me bail also, before 5-6 days I cannot come because I have to send it to Silchar. It will take 3 days to go.
you find out.
Private one.
Let him find out.
Yes.
Item 6. That is similar to item 4 lordship. 6.5 kg lordship of these as the suspected we will be recovered from the hotel lordship. And we were arrested on 1st of July lordship, that is, and produced on 2nd of July, so altogether today is 3 days. Lord.
1st of July.
1st of July, produced on 2nd of July, today is 23 days lordship.
Where is the affair?
Well, lordship will find on page 10 lordship.
Why your prayer was rejected?
I have NF lordship.
Rejection order is there.
That on page 14 is a rejection order of additional session just of.
Where is the affair?
FR page 10 Lord. Simply the raid was conducted in a hotel and recovery was done.
How much?
Well, lordship is 6.5 Lord.
Okay. Heard Mr. S. Munir. Oh, item number 4, it will be similar.
CJM also same, Lord. Overbody.
Item number 4, 30,000 with one surety.
Or that not Salmara Overbody.
Okay. Same order with certain little changes. Same. This bail application is this also.
Item 7.
30,000 with one surety.
And also similar, we have 4 kg. Same place.
How many days?
Same days, Lord. So, 1st of July arrested, 2nd produced, today 23 days, Lord.
Where is the rejection order?
Rejection order, Lord. Final page. Page 13, Lord. Page 14, Lord. We start from 13, operative portion on page 15.
How much is the recovery?
4, Lord. 4 kg.
4 kg.
Lord.
4 kg. Petitioner's name will be different. Date of seizure, ये यहाँ से देखना. 30,000 with one surety.
SDGM will be same, Lord.
Okay.
Not certain. Much obliged, Lord. Much obliged.
8 also same. Yeah, page 11 is the affair.
Have you approached the trial court?
Yes. This is rejected method.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Basid Ali, number 2 Baharul Islam, number 3 Rafiq Ali, who have been detained behind bars since 1/7/2025 within bracket for last 24 days in connection with Abhayapuri PS case number 146/2025 under section 299 of BNS read with section 13(1) of Assam Cattle Preservation Act. The gist of accusation in this case is that on 1/7/2025, one Bholanath Vishwas had lodged an FIR before officer in charge of Abhayapuri Police Station, inter alia, alleging that on receipt of an information through reliable sources that the petitioners are illegally selling beef in contravention of the provisions of Assam Cattle Preservation Act, 2021, a search operation was conducted. During search operation,
7.2 kg raw meat, 3.82 kg cooked meat.
7.28 kg of raw meat suspected to be of beef and about 9 kgs about 9 kgs of cooked beef meat was recovered therefrom. Submission agor dutarji thakibo aro reasoning is also same. Objection will also remain same.
Call for different.
30,000 with one share. 30,000 each.
Item 9.
Disposal.
May it please the law. My lord, the petitioner is in custody for 59 days, my lord. Nothing is found against him, my lord. When three accused were caught red-handed, your lordship may be pleased to see the FIR page 14.
21C. The case diary would be required. We are calling for the case diary. Heard Mr. M.H. Raj Borbhuya, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. List this matter. When? 12. 12/8.
Item 10.
Obliged.
Please, Your Lordship. Case diary will be required, Lordship.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard K.K. Das, learned additional public prosecutor. Call for the case diary.
Lordship, I'm sorry, Lordship. The co-accused bail petition number 2308-25 fixed on 4/8, Lordship, on case diary.
List this matter along with bail application number 2308/2025 on 4th of August.
Much obliged. Much obliged. Item 11.
Yes.
Lordship, here Lordship has already released the co-accused. Lordship, I have annexed the orders, Lordship, from Annexure 3, Lordship, page 34.
What is the offense?
The offense is, the allegations are, Lordship, for assaulting the police officials, Lordship.
Case diary would be necessary. Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary.
13.
List this matter on 37.
13 too long.
12.
12 August.
Item 12.
May it please your Lordship. Lordship, regular bail application, offense under section Lordship 21C and 29 of the NDPS Act, Lordship. The second time bail application, Lordship, earlier rejected
Lordship will find that Lordship,
What is the ground?
Lordship, earlier it was rejected on merit. This time we have taken the ground that non-furnishing of Lordship ground of arrest. I have Lordship annexed the
Heard
law.
Mr. N. Hassan, learned counsel for the petitioner. Charge sheet has been
Charge
laid.
sheet has been laid. Now it is fixed for Lordship CC, consideration of charge.
Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned K.K. Das, learned additional public prosecutor. Yes, Mr. Das.
I have annexed all the Lordship notice, Lordship certified.
There may be some other document. Heard call for the scanned copy of the case diary
Along with the case record.
along with the case, along with the trial court records. So scanned copy of the trial court record. Let this matter be listed 19.8. How much contraband?
252 gram Lordship, heroin,
Heroin.
just above the commercial,
19th of August.
already 447 days behind the ballot. Could it be on 13 Lordship?
No.
Thank you, Lordship.
Item 13.
Next, please, the Lordship. Here is a case, madam, where the petitioner has lost the case a day before he was arrested, madam, against the informant's husband and others, madam. Then, madam, those persons were arrested, madam, and they went to the house of the petitioner at one.
Arms Act is there.
Lordship may kindly, arms act, madam.
When have you been arrested?
Lordship may kindly see, madam. May I submit, madam? I have a submission, madam. Page 16 is the FIR lost by me, madam.
Where is your rejection order?
Rejection order, madam, at page 20, as page 26, madam. Before that, madam, I have some submission.
Yes, yes, make your
Madam,
submission.
page 16, madam. Page 16 is the FIR lost by me, madam. Madam, Lordship may kindly see the date, 27/2025. Madam, here, my lord, those persons, my lord, went to my house, my lord, at 1:20 AM in the night, my lord. 1:20 AM in the night, they have knocked my door rigorously. They were shouting slogans, my lord. My lord, then they were, my lord, this is the affair lost by me, my lord. Then eventually, my lord, may I read the affair?
No, no.
Then eventually they were arrested. All the persons were arrested, my lord. And my lord, I have categorically stated that I have fired one round in the sky with my license gun. In my FIR, page 17, I have stated, and I have the valid license, that is at page 22, my lord. Page 22, I have got the valid license, my lord, which is valid till 31/12/28, my lord, 2028. Then eventually, my lord, those persons were arrested, my lord. On 27, they were arrested.
Where is the FIR against you?
My lord, those persons were arrested, my lord. Now, my lord, they have stated that page 9, my lord. May I read, my lord?
Yes.
My lord. With due respect, the informant begs to state that on last 19/7/2025 in the night, the informant's husband and the second party had financial transaction. My lord, though the informant husband owes an amount of rupees 15 lakhs from the second party, but the second party has not paid the same. On 19/7/2025 at around 1:20 AM in the night, my lord, as the informant's husband was called, then the Saddam Hussein, Badon Ali, Nilav went to the house of the second party, my lord, at 1:20 AM in the night and stopped near his gate and called the second party. Then the second party came out with a gun in his hand and with the intention to kill the informant's husband, and two others fired two gunshots, but no one has sustained any bullet injury in their body. In fear of their lives, they escaped from the aforesaid place and took shelter at Misa police station. Again, Biju Samare came to Misa police station with a gun and threatened my husband. This is the case, my lord. Well, they went to my house, my lord, at 1:20 AM in the night. Now, my lord,
Why your prayer was rejected?
my prayer was rejected in initial stage, my lord. That's why, my lord. But my lord, but Lordship may kindly see what offense I have committed. And they went to my house, my lord, at 1:22 for financial transaction. And two of them, unfortunately, were my lord, police personnel who went along with them, my lord.
No, let us peruse the rejection order.
Lordship.
whether the
But Lordship, before
case
that-
diary was perused.
No, my lord, no, not with case diary was not paid with my lord. Lordship may kindly see page 22, my lord. The license gun, my lord, I have fired, my lord.
Okay.
But my lord, I have mentioned in my FIR that I have, my lord, I have fired my lord, one round, my lord, to my lord, because they were knocking my door, my lord. If Lordship reads my FIR, page 16, my lord, it will be clear, my lord. Page 16, my lord. They were arrested in connection. After that, my lord, one of the accused person's husband, wife, my lord, she has lost the case, my lord. Then only I was arrested, my lord. And Lordship may kindly see, my lord, my affair, I have categorically said, came in a Bolero car at 1:20 a.m. in the night, my lord. For financial transaction, my lord. May I pray, my lord? And at best, if at all any section is attracted, my lord, it would be, my lord, if at all, my lord, section 30 of the, my lord, Arms Act, my lord, that is a bailable one, my lord.
What is section 30?
Section 30, punishment for contraventions of license, my lord. That also I have not contravened, my lord. I have fired in, my lord, in the sky. And my
Since when you are behind the
my
bar?
lord, behind the bars, my lord, recently, my lord, but no offense has been
Oh, okay. Since when you are?
since my lord, 20.
Yes, Mr. Parashar.
It's 21/7, my lord. And
It seems that he has a case.
one, but yes, he once he blamed for other 2% also fair 2 rounds of ammunition, my lord. At this stage, without perusing this CD, my lord, it is difficult.
But if somebody goes to your house at 1:30,
Yes.
For financial transaction, my lord, what I will do, my lord. And my lord, no one was injured. Everyone was, but they were arrested, forwarded. Each and every person who went to my house. And any stringent condition.
Informants also carry.
which is the police station?
Samuguri, my lord. Samuguri, my lord. But here, my lord, Lordship may kindly see, my lord. Without anything, my lord, I am in jail, my lord, because no fault of mine. They went to my house for dacoity, my lord, commission of dacoity. They were arrested. Then one of the accused person's wife, my lord, he has lost the case against me. That one I have.
Yes. What is the submission, Mr. Parashar?
Rejection of the my lord, last part, page 27. During investigation, one gun license was seized from the house of with empty case of loaded ammunition, and the accused is not the license holder of the same.
No, man, I have, and at this moment, I have annexed my license, my lord.
Where is your license?
Page 22, my lord. It is still valid, my lord. Page 22, it is valid till 31/12/28.
Heard, Mr.
But my lord, regarding my lord, fired ammunition both sides, my lord, that side also fired two rounds of ammunition, my lord. At this case, calling of the city, my lord, only arrested on 21/7.
But my lord, no fault, my lord.
Heard, Mr. S.M. Abdullah P., learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, who has been detained behind the bars since 21/7/2025, within bracket for last 4 days, in connection with Samuguri PS case number 160/2025 under section 109/296/351 within bracket 3/3 within bracket 5 of BNS, read with section 27 within bracket 1/30 of the Arms Act 1959. The gist of accusation in this case is that on 21/7/2025, one Shamim Akhtar had lodged an FIR naming therein 3 accused, including the present petitioner, inter alia, alleging that on the night of 19/7/2025 at about 1:20 a.m., the husband of the informant was called to the house of the petitioner for in connection with a financial transaction, and stop. It is further stated in the affair, when the husband of the informant went there along with some of his friends, the petitioners, the petitioner came out with a gun in his hand and shot fires. It is further stated in the FIR that no one has been injured in the gunfire. However, later on the petitioner, it is alleged that the petitioner had threatened the husband of the informant and his friends with dire consequences. Learned counsel for the petitioner has submitted that the accusation made against the petitioner in the FIR are not true. He submits that, in fact, before filing of the FIR against him on 27/20/25, the present petitioner had lodged an FIR against the husband of the informant, namely Shaddam Hussain and two others. Stop. It is submitted by learned counsel for the petitioner that in his FIR he has alleged that the husband of the informant, it is alleged that Saddam Hussein, along with his accomplice, with intention to commit dacoity, came to the house of the present petitioner in a Bolero vehicle at about 1:38 a.m. Stop, and started thumping the doors of the house of the petitioner. Stop. On this, the petitioner, who is holder of a licensed gun, came out with his gun and shot blank fire to and on which the accused persons fled away. Learned counsel for the petitioner submits that the FIR registered by the present petitioner was FIR filed by the present petitioner was registered as Samaguri PS case number 159 of 2025, and the accused persons named therein were arrested. Stop. He submits that now, out of vengeance, the wife of the accused person, one of the accused, has filed a false FIR against him. He further submits that before approaching this court, the petitioner had approached the court of learned, which court? Judicial Magistrate First Class, seeking bail. However, his prayer for bail was rejected, and wherein an observation was made that the petitioner is not a license holder of any gun. Learned counsel for the petitioner submits that the petitioner holds license of the gun which was used to threaten away the accused, the husbands of the informant and his accomplice, who came to the house of the petitioner on the night of the 21st, on the night of the 19th July. In support of his submission, learned counsel for the petitioner has annexed his license as annexure 4. Stop. On the other hand, learned additional public prosecutor has submitted that, considering the accusation made against the petitioner in this case, perusal of the case diary may be called for. Stop. I have considered the submissions made by learned counsel for both the sides. It appears that the petitioner had lodged an FIR on 21st
On 20, my lord.
on 20 against the husband of the informant of the FIR lodged against him. It also appears that the petitioner is the holder of a license, is the license holder of a gun, and the license is valid up to 31/12/2028. Stop. Stop. Call for the case diary. List this matter on 14th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in foregoing paragraph, the petitioner is allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief as just Subdivisional Judicial Magistrate Mufassal Poliabor with following conditions, number 1 and number 2. List accordingly.
Oblige, your lord.
It's okay. Conditions from Abhishek. Take conditions from Abhishek. Yes.
May I please, my lord?
My lord, FIR on page 11, my lord. In the FIR, my lord, informant alleged that, my lord, his minor girl, my lord, allowed to the petitioner number 1, my lord, and on 19/5/2025, my lord. In the same day, my lord, petitioner come to know that the family members of the informant searching the minor, the victim girl, as victim girl, my lord. He returned the victim girl to the house of the informant, my lord. That is the FIR, my lord, only. After receiving the said FIR,
For issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 19th of August. Stop. However, in the meanwhile, considering the submissions made by learned counsel for the petitioners as discussed in the foregoing paragraphs, comma, all the above named petitioners are hereby directed to appear before the investigating officer of the Rupohi RPS case number 182/2025 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. List accordingly.
published.
Item 15.
My lord, your lordship will find, lord, the FIR at page 11.
Yes.
Now, my lord, page 13, lordship will find receipt and register where 147 is, my lord, implicated. That is, my lord, substitutable position. Now, charge sheet, lordship will find at page 20.
What is the offense?
My lord, offense, my lord, registered under section, my lord, 61(2), 147, 196 1B, 294, 318 4, 336 P, 342, BNS, read with section 14 of the Foreigners Act 1946, read with section 13 of the Foreign Exchange Management Act 1999.
It is a charge sheeted case.
Charge sheeted case. Charge sheet lordship will find at page 20.
Why are you apprehending arrests?
Because since section 147 is a session tribal,
What is the punishment for 147?
10 years.
Death and imprisonment for
Death.
life. Waging war lordship. Against it. No, no.
You are shown as an absconder.
And ultimately, someone has been issued and date is fixed on 1989 for appearance. So only limited period he will appear and on appearance he may be allowed to go on bail. But that must be limited. Otherwise, it may
No,
be committed to the session court.
What is your involvement?
Involvement, lordship, so far the
The offense are of serious nature.
involvement, lordship will find from the affair, it is entirely against on Abdul Hasinur, who was arrested and released on bail by the trial court. The content of the affair says, my lord, page 11. Allegation, my lord, allegation is, my lord, we took rupees 2,000 from the Bangladesh nationals and as well as Indian nationals to cross the border. That is the allegation.
Yes.
Since the allegations are waging war against the state and he has not cooperated during entire investigation lordship. So I have apprehension of
Waging war, how it comes in this case?
as a charge sheeted case also lordship.
We have annexed, my lord, substitute, we have annexed, my lord.
147 is also.
That is why, my lord, since it is session tribal case, my lord, case may be committed to the session court, my lord, so we will be behind the bar, my lord, unnecessarily. So we will cooperate with the, my lord, trial, my lord, proceeding. Condition, my lord, we may be allowed to go on bail.
Oh, do you have right to get bail in this case? You are submitting as if you have a right to get bail.
Now,
You have to justify. Suppose you are accused of an heinous offense merely because the committal court is under statutory embargo. Statutory embargo is there that committal court cannot grant you bail. Is it sufficient that you can claim bail? Or you have to satisfy the court that you are regarding your involvement or other facts?
yes, that's true, my lord. So far the affair is concerned, my lord, and the, my lord, charge sheet is concerned. There is no specific allegation against the petitioners.
How many?
Only allegation against the, my lord, Abdul Hasinur, who was arrested and released on bail by the trial court subsequently.
Abdul Hasinur has.
Arrested, my lord.
What is the accusation against you? What is
Yes.
the allegation?
Allegation, my lord, lordship, we have already, my lord, read over, my lord, page 12, lordship will find, page 12, third
Yes.
paragraph, my lord. The
Yes.
accused Abdul Hasinur Islam and others by facilitating illegal entry into India have evaded the commission of offence related to entry into India without valid passport, visa, etc. That apart, they have also helped in the preparation of the fake ID by processing the fake documents, thereby committing the forgery related to offence. These Bangladeshi nationals and their agents are also found to be hand in glove with the terrorist groups prescribed by Indian law. They are working with the elements in its also territorial unity and integrity of India and thus indulging in various
Regarding this allegation, subsequent
during preliminary investigation, the apprehended accused Abdul Hasinur Islam stated that he along with other co-accused, these are the accused who have been implicated by Abdul Hasinur. Therefore, I lost an affair against the involved Abdul Hasinur Hasinur Islam, and below mentioned
No,
other.
your association with terrorist group, is there any material?
That is, there is no materials on it. It is only stated in the.
You
FIR.
don't know, because what documents are annexed along with the charge sheet, you have not yet received those documents.
No.
When is the date fixed?
Next date is, my lord, 18/9/2025.
18/9. We'll call for the scanned copy of the case diary. We'll go through what materials are against you. Heard Mr. M.U. Mandal, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of accusation leveled against the petitioner,
Next date.
perusal of the scanned copy of the case diary would be necessary. Hence, call for the scanned copy of Mankachar PS case number 1/2025 from the court of which court it is pending?
Lord, Sub-Divisional Judicial Magistrate Court, M. Hatsingimari.
From the court of learned SDJM M. Hatsingimari, the registry to take steps for requisitioning the scanned copy. Let this case be listed 20 August.
Lord, PRC case number 87/2025.
Okay, there.
Development.
Item 16.
May it please your lordship. This is a pre-arrest bail application of the accused petitioner, my lord. The FIR is at page 20.
Yes.
Now, the gist of the FIR is, my lord, one, if your lordship looks at the 6th line, during the operation, total 1.5 kg suspected cooked beef meat. It can be for personal consumption, it can be for sale, we don't know. They also think that it is suspected.
Who are you?
They say that I am the owner of the hotel and I was not present at the time when the seizure was done. And all the sections are available except section 13(1), because your lordship knows under the Cattle Preservation Act, it is section 8. But first you have to come with a conclusive evidence that it is beef. Then only the burden will be shifted. They themselves say that it is suspected cooked beef. And your lordship knows that if it is cooked, it's very difficult to determine what it is, what meat it is, because ginger, garlic, masala, everything will be added. After that, that DNA will also not be successful in determining the meat, what type of meat it is. Chemical analysis useless. DNA, which is normally the golden test for this kind of thing, but in many cases where trial are going on, I have seen that even the DNA has not been successful in case of cooked meat. So my respectful submission is that since it is a very small quantity, 1.5 kg, and it is cooked suspected beef, I think, my lord, the police have better things to do than pursue this small petty offense, because in 2 sections, punishment is for a fine of 10 to 50 rupees.
Yes, Mr. Das. Let him appear. Let him appear. Heard Mr. B.D. Kaur, learned senior counsel, assisted by Ms. Mzo Wangpui, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Azahar Mandal, alias Bhola, who is apprehending his arrest in connection with Kajalgaon PS case number 111/2025 under section 325 of BNS, read with section 13(1) of the Assam Cattle Preservation Act 2021. The gist of accusation.
But there is another section also, section 11(1) of the Prevention of Cruelty to Animals Act.
Yes, yes, as well as section 11 within bracket 1 of the Prevention of Cruelty to Animals Act 1960. The gist of accusation in this case is that on 1/7/2025, one Sumanto Chandra Burman, SI of Police of Kajalgaon Police Station, had lodged an FIR before the officer in charge of Kajalgaon Police Station, inter alia, alleging that on that day, a credible information was received through reliable sources that certain hotels located in Baikhungaon are regularly selling beef meat in contravention of the provisions of Assam Cattle Preservation Act 2021. Stop. A search operation was accordingly conducted, and during search operation, 1.5 kgs of suspected cooked beef meat was recovered from the hotel Asmina. Stop. Learned senior counsel for the petitioner has submitted that the petitioner is the owner of the aforesaid hotel and he is ready to cooperate in the investigation. He further submits that since the suspected beef meat has already been recovered, there may not be any requirement of custodial interrogation of the petitioner. On the other hand, learned additional public prosecutor praised for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both the sides. Considering the quantity of meat recovered in this case, as well as the fact that suspected beef meat has already been seized, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of Kajalgaon PS case number 111/2025. Stop. For the reasons discussed herein above, this anticipatory bail application is disposed of with a direction to the petitioner, above named petitioner, to appear before the investigating officer of Kajalgaon PS case number 111/25 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Number 1 and 2. This anticipatory bail application is accordingly disposed of.
Yeah, bless me. Like instead of 7 days, your lordship will kindly make it 10 days because Friday, Saturday, Sunday, from today.
10 days.
10 days. Yeah, bless me.
10 days করে দেব।
Item 18. May I please, your lordship? Here in this case, lordship, the FIR is at page number 13, lordship. Listed under section 192, 196, 299, and 300 of the MS, lordship. Page number 13.
Oh, this is more serious. Accusation are
Not against me, lordship. Otherwise, lordship, I'm not playing for interim, only playing for shortage, lordship. Because lordship, the narration, lordship, this is there in the FIR.
case diary would be required.
May be required, lordship, and.
No, it is required.
Yes, lordship.
only praying for a short date. Lordship.
I don't have the FIR, Lordship.
Yes, I'm sorry, Lordship. I'm not praying for interim, Lordship. Lordship, may kindly give me a short date.
Yes. When can you produce the case diary? Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of accusation made in the FIR, the perusal of case diary would be necessary in this case for consideration of the instant anticipatory bail application. Hence, call for the same.
Yes, Lord.
7th of August.
Hello.
Item 19. For 82 application, my lord. Page 13 is the FIR, kindly see. There are 19% have been named in the FIR. My name is also there, our name. My lord, story is different, my lord. Kindly, that is the story, my lord.
Yes. Wow.
So, my lord, whatever most of the sections are available except this snatching of the arms.
From
My-
police.
my-
You snatched arm from police.
Yes.
Case diary would be necessary.
Well, the case diary will be required, but my lord, this is exaggerated affair. What happened? They said that 500 people have gathered there and they wanted to know the persons of the informer. Then there was the plastic which was there suspected to be
Heroin.
has not been seized. No case under NDPS.
No, they were unable to do that because of the resistance.
But the question is that, my lord, they said they opened fire. They opened fire. They have admitted. And they said my arms was taken away again. I taken back and I opened fire to disperse the gathering.
What is your name?
There are all the persons are there. 15 persons.
All have a
Yes, all not 15 minutes. Some have been arrested. And there was no TIP till today, my lord. Out of 500 people, how they will gather? That is also in the night.
case diary would be necessary. Heard Mr. S.C. Bishwas, learned counsel for the petitioners. Also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of accusation made in the FIR against the present petitioners, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Let this matter be listed on 13th of August.
13th, 14th better.
14. Okay. Take the better date. 14th.
20.
Possible for the pending.
Okay.
Item 64 supplementary list.
May please also. My lord, pursuant to the order of this honorable court, I have filed the additional affidavit. Lordship.
What is there in the additional affidavit?
Lordship, can kindly see paragraph 3 and 4. I was directed to record as to why I need, on what ground I need transit and anticipatory bill.
Yes, now what is your case?
Lordship, can we come to page 8 also? This is the notice under section 35(3). This notice was served upon me, directing me to appear within 5 days of receiving of the notice. The alleged offence is committed in the state of UP, Lordship. And I am a resident of this state only. So my humble submission that I will appear and I will file the bail application before the concerned court, jurisdictional court. And to accommodate that, I may be allowed to go on transit anticipatory bail. Lordship.
Where is that judgment?
Lordship may kindly say. Yeah, Indora, yeah.
You have given copy to the court master.
Third day I saw a copy is already here, Lordship.
Priya Indoria আছে. Heard Mr. Yes, Mr. Das. Let
We have to give reasonable and justifiable grounds to why cannot vote your Lordship. That basis, Lordship.
What is the accusation? In what case you were required?
Page 8, Lordship. 318 subsection 4, Lordship. 18. But I am not involved. I am not at all aware about the fact, Lordship.
Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Rafiqul Islam, seeking transit anticipatory bail as he is apprehending his arrest in connection with what is the case number?
Case number FIR case number 009725.
In case number 0097/2025, registered at the Cyber Police Station, Commissionerate, Ghaziabad. Stop. Learned counsel for the petitioner has submitted that the petitioner has received a notice from the Cyber Crime Police Station, Commissionerate, Ghaziabad, in the state of Uttar Pradesh, under section 35(3) of BNSS, asking the petitioner to appear before the Cybercrime Police Station, Commissionerate, Ghaziabad, Uttar Pradesh, within 5 days of the receipt of the said notice. It is submitted by learned counsel for the petitioner that the petitioner is a permanent resident of the state of Assam and is not acquainted with any other language except Assamese. He is also not acquainted with the he has also stated that he has never visited the state of Uttar Pradesh on any earlier occasion. It is also submitted by him that he is not involved in any offense under section 318 within bracket 4 of BNS 2023 and section 66D of the IT Act. He further submits that he is unaware about the detailed accusation against the petitioner. He also submits that he is ready to appear before the Police Commissionerate, Ghaziabad, in pursuant to the notice under section 35(3) issued to him. However, as the offense indicated therein is non-bailable offense, he apprehends that he may be arrested. He has also submitted that he would appear before he shall approach the jurisdictional court in the state of Uttar Pradesh seeking appropriate relief from the said court. However, to facilitate him in approaching the aforesaid court and aforesaid court transit, he is praying for transit bail, transit anticipatory bail. Learned counsel for the petitioner has submitted that under such circumstances, this court can grant transit anticipatory bail, as has been observed by the apex court in the case of Priya Indoria versus State of Karnataka and others, reported in 2024, 4 SCC 749. On the other hand, learned additional public prosecutor, are you opposing?
He can take the help of an engaged counsel and go there, if he does not know.
Learned counsel for the learned additional public prosecutor submits that the reasons for seeking transit anticipatory bail, as mentioned by the petitioner in his petition, is not justified. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the records of this case. Since the petitioner has mentioned the reasons for which he could not approach the jurisdictional court seeking appropriate relief, and since he is ready to cooperate in the investigation and also ready to appear before the investigating officer of Cyber PS case number 0097/2025, under Cybercrime Police Station case number 009/2025, this bail application is disposed of with a direction to the petitioner to appear before the Cybercrime Police Station Commissionerate, Ghaziabad, UP, in connection with case number 0097/2025 within a period of how many?
Provide the 4 weeks time at least also. Because I have to go there, I also need some escort and counsel also I required. Also to make an arrangement to go there. So at least 4 week time will be given.
4 weeks, maybe 3 weeks.
Otherwise I'll be in program also.
4 weeks time. 4 weeks time. And cooperate in the investigation. If he does so, he shall be, in the event of his arrest, in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with a suitable surety of like amount subject to the satisfaction of the arresting authority. Four weeks completes on when? He shall appear before.
Within 26 August also.
This interim anticipatory bail shall be operative till 25th of August 2025 only. So as also to enable the petitioner to approach the court of competent jurisdiction for seeking appropriate relief from the said court. This anticipatory bail application is accordingly disposed of.
Item 21. Notice. Accepted case that accusation is serious that.
Well, before Lanak can start, one thing is that I have gone through the record. It is up to 27/3/25. Subsequent date, financial capacity is not come. Till then, 13 of this exam.
How many? 13.
13. The next up to 12. 12. Up to 12. PW I have the next one.
What is the offense?
Offense position is serious 365, 376 DA, 306.
DA.
DA.
DA means gang rape.
Gang rape. And 6 of POXO.
Yes, what is the submission?
Although the position is serious, petitioner is not involved in that. She is detained behind the bar last 2 years.
Who is the petitioner?
Petitioner is Rafiqul Islam.
What is the accusation against you?
Yes, your lordship will find the FIR.
7th August. You have understood my query. You have to show something. List accordingly on 7th August. এইকেইটা separate file বনাই ৰাখিব। না আমার কেইটা ওলাই রাখো। Judgment বিলাক separate ফাইলত ৰাখিব। Okay, 7th August.
Pending item 20.
Item 20.
Wait, please, Lordship, my lord, here the allegation of the police is that, my lord, they have seized about 80 kilo of 88 kilo of beef, my lord,
80,
8 kilo, they say.
80.
Yes, 88, double eight. That will be fine. Okay. The seizure was made, my lord. My shop is at Dolabari. Your also knows because
You are a shop owner.
owner, but the manager was running the shop, my lord. He was arrested and he obtained bail from the Alcourt itself. And now he was not there at the time. The seizure was from Dolabari, my lord.
Your shop is a meat shop.
Food. Food kiosks, my lord. Hotel.
It is a hotel.
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 Yes. Cheese, meat, everything.
It must be a very big hotel.
Not big, you also might have seen while crossing the river Brahmaputra, my lord, just Dolabari, left side, there is a hotel. Small hotel. So big a room.
No, 88 kgs is
88
large.
kilo, my lord, it is not sure, my lord, what is beef meat or buffalo meat or whatever it is. And my
Okay, what is your submission?
submission, my lord, while the your lordship can come to seizure. In the seizure, my lordship knows on section 103, subsection 4 of the PNS, there must be independent local witness. The witnesses put here are all government servants and they are not independent. A lordship only come to page 13.
Now, how it helps you?
Because if the seizure is bad matter, then the entire proceeding ultimately goes
Now,
long analysis. And moreover, the man was not there. Caesar was made at Dolabari. They have started in 10 mile. 10 mile is long, far up from there, about 4 kilometers away. Kindly come tomorrow. FIR is that 88 kilos beef was found. Whether it is beef or not, that was also not certain.
from your hotel.
My hotel is mine. But manager were running, manager were arrested, and he was granted bail after seeing the case diary by the trial court.
Who was released on bail?
His manager
Manager has been released.
releases.
Okay.
You are also forwarding.
Now, what is your submission?
Submission matter that I was not in the hotel. Manager was hotel, I have opened the hotel, no doubt. Finance is mine, investment is mine, but manager are there. He was managing everything, purchasing a meat or whatever items, because they are even mutton, fish, chicken, everything is sold. But it is not certain whether it is beef or not. And one more thing you also can see from the Cattle Procedural Act, up to 14 years you cannot kill a cattle, cow.
No. Is it within the prohibited area?
No, that is a minded area. You also knows about Tezpur, every geographical location you also knows. You have been there. So, not prohibited. Dolabari is totally minded area. There is no other communities living there. So there is no question of creating disharmony or anything. Section 13, my lord.
You can sell beef only in places which are permitted by competent authority. Whether you had that permission, that is the only violation.
No, our hotel is married long before the 2021 Act came into being. So, there was.
But after the act comes, you should take permission if you want to sell beef, because this statutory provision still holds the field.
Yes.
So you have to take. Otherwise, 13(1) offense is committed.
Yes, that is true. Generally, my lord, what happened in my hotel, if is rarely sold because the drivers go and eat, my lord. Drivers of different communities, different religions. They mention. So beef is hardly cooked. Hardly cooked. Unless the forensic laboratory report comes.
No, it is a quantity is 80. Quantity may be more or less. Quantity even 1 kilo or 2 kilo will, beef is beef after all, it is beef. Quantity doesn't make any difference. The difference is whether it is a beef or not. First thing. In the FIR, it is.
No, so your submission is, it is not beef. Hotels is yours.
This is mine,
You-
but I'm not running it, run by manager arrested and released the bail
Okay.
on examination of the case diary. An FSL is required, Lordship. Otherwise, Lordship, without permission also. In the FIR, it is also stated the sale of beef without permission.
Okay, heard, Mr. Let us call for the case diary, give him interim. Heard, Mr. R.P. Sharma, learned senior counsel assisted by Miss M. Bora, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by the petitioner, namely Hafizul Haq, who is apprehending his arrest in connection with Tejpur PS case number 456/2025 under section 299/196 within bracket 1 within bracket B/3 within bracket 5 of BNS 2023, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on one, who lost the affair?
Police was there.
One, the as in charge of Borghat or Borghat?
Borghat.
Borghat
Is far away.
police outpost lodged an FIR before the officer in charge of Tejpur police station, inter alia, alleging that on receipt of an information through reliable sources regarding illegal slaughter and selling of beef meat in the Hotel Khwaja Garib Nawaz located near Dolabari, located at Dolabari, a search team was constituted. Stop. During such operation, about 88.12 kgs of raw beef meat was recovered from the said hotel. Stop. Learned senior counsel for the petitioner submits that he is the owner of the hotel and it is managed by his manager Hajrat Ali.
Yes.
He submits that the manager Hajrat Ali, who was arrested, has already been granted bail by the trial court. He further submits that as the suspected beef meat has been seized, his custodial interrogation may not be necessary, as he also submits that in his hotel, apart from beef meat, the other meat like mutton and chicken are also served. He also submits that as the hotel is managed by his manager, he is not aware as to what is being served there on daily basis. He further submits that the petitioner is ready to cooperate in the investigation. However, as the provision under section 13(1) of Assam Cattle Preservation Act is non-bailable, he is apprehending his arrest. On the other hand, let us dispose it of. Let you, on the other hand, learned additional public prosecutor has opposed the grant of anticipatory bail at this stage and has prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both these sides and have gone through the materials on record. It appears from record that the suspected beef meat has already been seized in this case. It also appears that the manager of the hotel of the petitioner who was arrested in this case has already been granted bail on 15/7/2025 by the Court of Learned Additional Chief Judicial Magistrate Sonitpur. Stop. Considering the above facts, this court is of opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid investigation of Tejpur PS case number 456/2025. Stop. In view of above, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of Tejpur PS case number 456/2025 within a period of 7 days from the date of the 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Disposed of.
It is your lordship.
Yes.
483 application. This case was earlier rejected. Now this petition has been filed on the ground of lordship, non-furnishing grounds of arrest. Page 15, I have annexed the notice, lordship.
What is the offense?
Offense, lordship, would be pleased to find at page 11. May I read the contents of the affair, lordship? Is a commercial. Here, lordship, some cough syrup has been seized from the house of one Narayan Nath.
What is the date of your arrest?
My date of arrest is 4/2/2024, and now I have completed 1 year, almost 6 months, lordship. 1 year, 6 months. And that but I am a 73 years old man, lordship, suffering from various old age ailments, lordship.
1 year?
6 months.
Exact.
Exact, lord. Almost. I have calculated, and
What is the exact period?
yes, on from 4 to 2024, that is 25 days in 25, and then up to 31/12/2024 is 1 year.
No,
then
not in that manner. You calculate and we'll take it up after some time. You come after proper calculation.
1 year, 6 months, lordship.
Because if in this case, if it is more than 1 year, 6 months, then there is a probability that you may get bail on that ground. Otherwise, not.
This, yes, 1 year, 6 months is already there, lordship, and there.
No, you are unable to regarding grounds of arrest.
Yes.
This
And lordship.
this is before the judgment of Pankaj Bansal.
This is not before, this is after.
4/2/2024.
Lordship.
In this second also on day before yesterday, Lordship, one argument was made, Lordship, regarding that issue also, Lordship, regarding after Pankaj Bansal issue, Lordship.
No, after Pankaj Bansal, if it is
Lordship
She was allowed by number of.
when
on Tuesday, Lordship.
when those cases are fixed.
Those cases are fixed today, Lordship.
My health condition is not very well, Lordship. That is.
No, no, we'll dispose it of today itself.
Yes, Lordship. I have suffered and nothing.
You are ready with the written.
No, Lordship. Today I'm going to seek one day accommodation, Lordship, in that cases, Lordship. Preparing it, but I could not complete it, Lordship, yesterday, Lordship.
Lordship, because in the
on Monday or
same
10th.
line, Lordship, in this same line, Lordship has delivered.
You don't have a strong case in.
Even though I'm trying to convince.
Lordship.
I'm preparing.
Today, Lordship, end of the day, he can answer it if anything, because in the same line, Lordship and
Going through some
Lordship,
other questions, Lordship. So
Lordship has disposed of number of applications, Lordship, where I'm covered. Those I'm covered, Lordship, and
Okay.
this is a man, Lordship, he is suffering.
No, okay. Okay, you come with the computation. We'll take it up in the second half.
Second half, yes, Lordship.
Second half, we'll take it up. In the at 2. At 2, we'll take it up.
Item 24.
Yes, Lordship, in this case, your Lordship, what happened under section
Justice
48 of BNSL does not follow, your Lordship. And no any notice has been issued to the family members of the accused person, your Lordship. There are fundamental rights.
And charge sheet has been submitted.
Lordship, my lord, on
What is the offense?
Since is your Lordship, the articles are recovered 4 kg of
Marshal law.
morphine, your Lordship, but that vehicle is not from me, your Lordship. That is the another person, and I have taken the rent on the.
Commercial quantity of contraband.
30th of June, my lord, charges submitted.
47 and 48 of BNSL does not follow in this case, your Lordship. There are fundamental rights, article 21 is IMC.
Scan copy of the case diary would be.
Yes, can be what will come, my lord.
Yes, Lordship, can
email-
maybe call for you now.
Approve the code below once.
If it is a commercial quantity,
My lord.
then the
It's submitted on 30th of June.
you approach before the trial court.
It is the depot code, your Lordship. Kindly scan copy maybe call for your Lordship. Kindly give me one chance, your Lordship. Because 47, 48 does not follow in this case.
Where have you have taken that stand? In this case, that 40. Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that in this case, charge sheet has already been laid, bearing charge sheet number.
Charge sheet number 26/2025 dated 3/06/25.
On the other hand, learned additional public prosecutor. On the other hand, Miss A. On this, Miss A. Medhi, learned counsel for the petitioner, submits that the petitioner is pressing for bail in this case on the ground that the petitioner was not furnished with the grounds of arrest at the time of his arrest. And therefore, there has been violation of the constitutional.
That plea is not in the petition, my lord.
It is not there.
Not in the.
You said that it is there.
Yes, Lordship.
Which paragraph? Not.
Kindly give me one chance, your Lordship.
No, if you make wrong submissions before the court, no indulgence will be granted.
It's not a wrong submission, your Lordship. Kindly.
I asked you whether you have taken that plea in the petition. You said yes. So whatever you submit before the court, that has to be honest submission. If you make dishonest submission, this court will give no indulgence to you. क्या लिखा? In view of the laying of the charge sheet by the, in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail before the said court if so advised. You approach the trial court.
Item 25.
Please, Your Lordship, just kindly pass over for timing notes.
Okay.
Item 26.
Not clear, Your Lordship. Your Lordship, the petitioner is in custody since 13/7/2024. And Your Lordship, my main ground for paying for bail is that while furnishing notice under section 47 and 48, that grounds of arrest were not communicated to the petitioner. That Your Lordship will find page 23.
Foxo is there.
Yes.
Let the amicus come.
At 2.
Okay, at 2. At 2. Yes.
Item 27.
But say on the last occasion, the complainant was to be informed by honorable people.
Whether notice has been served.
I can be appointed also because this service report is still awaited also.
Heard. Mr. I.S. Majumdar, learned counsel for the petitioner. Also at Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that he has taken steps for issuance of notice upon respondent number 2. On the other hand, learned additional public prosecutor submits that he could not get information regarding the fate of notice issued to the respondent number 2. However, he submits that considering the nature of this case, an amicus curiae may be appointed to defend the cause of the respondent number 2 in this case. Considering the submissions made by learned additional public prosecutor, this court also intends to appoint one amicus curiae. So accordingly, Ms. M.K. Brown is appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall furnish the copy of bail application to the newly appointed amicus curiae. The registry shall reflect the name of Ms. M.K. Brown as amicus curiae for respondent number 2 in the cause list henceforth. Let's list this matter on 13th August.
Item 28.
Petitioner is behind the bar for 104 days. Delegation under section 6 of POXO. Lordship, charge sheet was filed under section 4 of POXO. FIR is 12.
Also, I'm sorry, Lordship, but as per the records, Lordship, the Last date was 18/6/25 for charges.
Framing of charges.
That is not, after that, what happened also, it is not clear. Last order is of 4/6/25, whereby Lordship, 18/6 was fixed for framing of charge.
What is your submission?
So far my information, Lordship, special judge is not
Not?
available, Lordship. Special judge on transfer, Lordship, is not, she is not. I see special judge Kuprajar, Lordship. So there is no progress, Lordship.
No, so on 4/6/25, it was fixed for framing of charge on 18/6.
Yes, what is the submission?
On that part as to whether the court is vacant or not.
Otherwise,
Delegation per se appears to be whether they were in a relationship and get eloped together. Problem is that this has not happened once. This has happened multiple times. As per the FIR, records will reveal that part. If it had been a one-time incident, perhaps a lawsuit could have considered, but has been happening repeatedly.
but both of them are,
Yes, that part is there, but it's a relationship, and he is also my lord, he. But then his age is 36 years.
okay, that is a factor. And the victim is,
My lord,
As per effect, 16 years, 6 months, Lordship, and as per medical report, 17 years.
no, then we will call for the status. Heard, Mr. What is your name?
Yes, sir.
S. Alam, learned counsel for the petitioner. Also heard Mr. K. B. Sharma, learned additional public prosecutor, as well as Mr. S. Nawaz, learned amicus curiae, appearing for respondent number 2. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 18/6/2024, and there has been no progress. 18/6,
13/4.
13/4. So sorry. Since when you are behind the bars?
13/4/2020.
13/4/2024, and there has been no progress in the investigation. On the other hand, learned additional public prosecutor submits that the scan copy of the records which are available before this court are not updated, and it appears that the trial, the special POXO case number 39/2025 was fixed before the trial court on 18/6/2025 for consideration of charges. However, as to what happened on that day is not known. Considering the submissions made by learned counsel for both the sides, let a status report about the progress of the trial of special POXO case number 39/2025 be called for from the trial court. From the learned special judge Kokrajhar. List this matter on 13th of August. 13th August. Somebody would be in charge. Whether session judge.
Item 5.
Item number 5. Yes.
I should submit it, Lord.
Charge sheet submitted. Go before the trial court.
Leave it to your lordship, whatever direction you will give, I will follow.
Heard Mr. S. C. Vishwas, learned counsel for the petitioner, Also, Mr. K.K. Das, learned additional public prosecutor, who submits that in this case, charge sheet has been laid bearing charge sheet number
51/25 dated 21/7/25.
Considering the fact that the charge sheet has been laid in this case, this bail application is disposed of with an observation that the petitioner may approach before the trial court and may pray for bail, regular bail before the said court, if so advised,
Which may be considered, madam.
which will be considered.
Item 26. Pardon?
I'm not putting it in orders. It is just oral observation which will be considered.
Shall be considered, madam. That why that objection will be given.
No. Yes.
Your Lordship, may kindly turn to page 23. These are the notices given to the accused person and his family members under section 47, 48, 36 B BNSS. And my submission to the Lordship is that in those notices, Lordship, no grounds of arrest were mentioned also. And inspection memo also I have enclosed that your Lordship will find page 25.
This is otherwise grounds of arrest were informed or not. In this case, this Aroda case would be applicable.
This is Lordship after Pankaj Bansal, that is 13/7/24.
13/7?
24.
23 it is.
24.
This
Forwarding report Lordship of 24.
24. 10/7/24.
That is Pankaj Bansal is of 23, October 20, October 10. 6/10/23.
okay. What is your submission? Yes. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. S. Nawaz, learned counsel, learned legal aid counsel appearing for the respondent. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Vishnu Kahar, who has been arrested, who has been detained behind the bars since 13/7/2024 in connection with special POCSO case number 24/2024 under section 65 within bracket 1 of BNS, read with section 6 of the POCSO Act.
Procedure has not been followed under section 47. And my lord, this probate forecast.
Charge sheet case.
Charge sheet has been submitted, Lordship. This is not a charge sheet case, Lordship.
It is a NDPS matter.
Yes.
A commercial quantity.
Procedure have not been followed under section 47, and my lord, is.
What is the date of arrest?
13/1.
13/1.
195 days is today, my lord.
We'll call for the scanned copy of the records. Heard, Mr. What is your name?
Yeah, present.
Z? Z Hussain, learned counsel for the petitioner, as well as learned, also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner is praying for bail mainly on the ground that no grounds of arrest were furnished to him when he was arrested in connection with the Lakshipur PS case number 8/2025. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
2025, dated 31/5/25.
You appear before the trial court. Take this plea before the trial court. Violation of your constitutional right.
My lord, these charge sheet, my lord. Courts also passed the order, my lord. And I.
Yes, what is your submission? Whether as the charge sheet has been submitted, the best court now is the trial court, and your plea is violation of the section 47 notice. The documents are in the records available before the trial court. So that is the best court. You first.
That is there, but we will cooperate, my lord. But before that, my lord, I would like to submit. My lord, mere fact that this charge sheet has been submitted, my lord, will not indicate the illegality and unconstitutionality of the, my lord, mistakes committed.
No, that I agree.
That is also, my lord, well discussed, my lord, with the probing professor, my lord. And I have pleaded, my lord.
No, there is no dispute on that proposition. But this plea you can take before trial court also.
As per the judgment, my lord, when we are, my lord, entitled, my lord. So let the scan copy, my lord, come. We expect from this honorable court, my lord. As the other similar cases are also being given, my lord.
Let the scan copy of the case diary of Lakshipur PS case number 8/2024 be called from the trial court. The registry to issue requisition. Let this case be listed on 20 August. Both the cases.
Same case diary.
Item
Published, my lord.
Made to the lordship. Lordship may kindly have a look at order, my lord. 2107/25, my lord.
Where I will find that order?
My lord, court's order, my lord.
Or
Court's order, court's order.
Okay. Yes, you have annexed.
My lord, in fact, my lord, to be fair enough, my lord, it was produced on a Sunday, my lord, where the special judge was not sitting on that day. He was produced before the, my lord, CJM, my lord. And there I have moved an bail application that was rejected. But thereafter, my lord, no bail application was moved before the special judge, my lord. But I have filed an additional affidavit. It's in the record, my lord.
You can file before the special judge. Special judge will grant you bail if it is a fit case.
Yes, but now today is, my lord, 49 days, my lord. And the co-accused, my lord, that is also true, my lord. The co-accused also have been granted bail, my lord.
By the special judge.
By the special
So
judge.
you should have approached before.
That's true.
Where is the order of the?
My lord, I have annexed, my lord, at page 33 of my additional affidavit.
This is a trap case.
Trap case. In fact, my lord, the money was, my lord, received by that the other co-accused. Well, I'm praying on only on the ground of length of detention.
No, that is okay.
49
But
days.
your conduct of
That's
directly approaching this court without bypassing the trial court when there is no valid reason for the same, though there is no legal embargo in approaching this court.
yes, ma'am.
But when trial court is competent enough to consider your prayer,
That's true, my
what
lord.
is the reason for
But that's true, my lord. But in fact, my lord, our court also held, my lord, in the past. My
No,
lord,
there is no legal embargo.
yes,
That
yes, my lord. But our court held.
But why you are burdening this court by filing an application for bail when same relief you will get before the trial?
That's true, that's true, madam. That's true, madam.
Yes.
Yeah.
Where is the order of the, you have the case diary? 49 days.
49 days, Lordship.
What is the progress of the investigation?
It is going on, but the voice sample is there, Lordship, which is recorded, and it has given to FSL, Lordship. And moreover, CDR is also there, Lordship, from the service provider. It has not been received. Otherwise, materials are there, Lordship.
Okay.
Because the
Yes,
yes, Lordship. Otherwise, that's the co-accused, and he has given the direction by this person, Lordship. Deal has been between this person, the present petitioner, and the complainant. But he demanded 1 lakh, and it has negotiated at 50,000. It has all been recorded, Lordship. Then this person was instructed to take the money, Lordship. His role is different, and this person's role is different, Lordship.
Is it a trap case?
Lordship, trap case.
Trap case.
So all evidence are with you.
Lordship.
So what is the necessity further of beyond 49 days?
Lordship, investigation is going on.
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Marmeshwar Das. Marmeshwar Das,
Yes, my lord.
who has been detained behind the bars since 6/6/2026 within bracket for last 49 days. How many days?
49 days, my lord.
49 days in connection with ACBPS case number 36/2025 under section 61 within bracket 2 within bracket small a of BNS, read with section 7 within bracket A small a of Prevention of Corruption Act 1988. The gist of accusation in this case is that on where is the FIR?
Lordship will turn to page 18, my lord, the forwarding, my lord, it will be page 18, my lord, 18, my lord.
On 6/6/2025, one Diganto Bora had lodged an FIR before the officer in charge of ACB police station, interiorly alleging that the petitioner has demanded bribe from him to facilitate him in obtaining license of a newly opened wine bar. Accordingly,
Page 19, last paragraph.
accordingly, a trap was laid and the petitioner was apprehended while he was accepting the bribe of rupees 50,000 from the complainant. Learned counsel for the petitioner has submitted that the petitioner is seeking bail mainly on the ground of ground of the long detention, ground of period of detention undergone by the petitioner, as well as on the ground of parity, as one of the co-accused has already been granted bail by the learned special judge Assam. On when, where is the order?
On 1/7/25, page 33.
On 1/7/2025. In 1/7/2025, stop. On the other hand, learned additional public prosecutor has produced the case diary of ACBPS case number 36/2025 and has submitted that there are sufficient incriminating materials against the present petitioner in the case diary. He, however, submits that the investigation has fairly progressed.
Okay, in that point, only I want to point one thing, Lordship. Here it is stated that some more oral and documentary evidence are yet to be collected. That is why.
Stop. Investigation has fairly progressed and FSL report has not yet been registered, has not yet been received as regards the voice sample and voice sample of the petitioner. Stop. He, however, opposes the grant of bail on the ground that some relevant witnesses are yet to be examined, and as there are sufficient incriminating materials against the petitioner, releasing him at this stage may hamper the investigation, fair investigation of the case. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of ACBPS case number 36/2025. The co-accused, it appears from record that the co-accused Abhijit Burwa, who was also involved in the offense alleged in the FIR, has already been granted bail by the special judge court on 1/7/2025. Stop. It also appears that though there are sufficient incriminating materials against the petitioner in the case diary, however, the investigation has fairly progressed. Hence, considering the fact that the petitioner has already been detained behind the bars for last 49 days, this court is of considered opinion that if he cooperates in the investigation, his further custodial detention may not be necessary for fair completion of investigation of ACBPS case number 36/2025. Accordingly, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned special judge Assam with following conditions, number 1 and number 2. Send back the case diary. This bail. Yes.
One of the first para, my lord, he is behind the bar from 6/6, my lord. It was
Date of arrest 6/6.
6/6. I'm off. Obliged.
Item 42.
The 483 lordship, this is the NDPS case lordship, the commercial quantity lordship, but non-compliance of lordship for 57 lordship, notice lordship. Is the non-compliance of this lordship under 457. To the lordship 100 and around 160 days and behind the bar lordship.
How much is the contraband?
700 lordship, 739.19 grams powdery lordship, suspected to be heroin lordship. But there is
Where is the notice?
notice is lordship given 47 BNS lordship, not compliance the 48 lawsuit. The mandatory lawsuit 47 and 48.
Whether the relatives or family members were informed. Where? Where is the 47 notice? 47 notice has been given.
Yes, sir. Lawsuit. That one is here.
From this particular flag mark, your lordship, everything has
Oh,
been
you,
complied.
you specify that 48 notice.
Lordship, 48 notice, it is annexed in the bail application itself, page number 24 and 25.
48.
Yes, your lord.
Which
The
one?
bail application, arrest memo.
No, her submission is that apart from notice under 47, there is also requirement of furnishing notice to
I mean,
family members.
that is a 48 I have annexed there.
Which one?
A flag mark, with the flag mark intimation to family members. In fact, everybody has been intimated here. There are two accused here in this particular, in this instant bail application. There are two accused.
Yes, it is there.
Both of them have been intimated, the family members have been intimated, telephone calls have been made, the SP of the district has been intimated, everything has been complied with, your lordship. Even the arrest memo mentions the grounds of arrest, and the accused has signed. It is in fact there itself, the original is there, and they have annexed in the bail application itself at page number 24 and 25. At the bottom, the accusers themselves signed, and trial court order also it reflects where they had actually filed their first bail application, that they had been intimated about the grounds of arrest, and they had accepted that fact.
How you have sent this notice to
Where?
family members?
That's
Where
beautiful.
where is that?
It is there. And also to the SP. In fact, the latest service report to the police station in Manipur, the family members, they had been intimated also through the police station, local police station in Manipur. In Mizoram.
Maybe later on.
No, not later. This itself.
On 18 to 2025.
The purpose we didn't receive any notice.
And there's a report of the local police station also. If I may
Is
be
there
allowed to.
signature?
Yes, yes, signature is there. Right.
Urgent signature is there.
Signature of?
Signature of the relative of the accused who received the notice.
Where is that?
It is at the beginning of the this flag mark, your lordship, I'll have to show.
Give it back to him. You have only these two grounds. Third, Miss, what is your name? R. Rongmei, learned counsel for the petitioner. Also, what is your name?
E. Bora, Senior Standing Counsel, DRI.
D. Bora, Senior Standing Counsel, DRI. Flag it horizontally. Flag the bottom. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Reuben Kamlalson and Lalro Lun, who are detained behind the bars since 18 to 2025 in connection with DRI case number 27/CL/NDPS/heroin DRI/ZZU/2024-2025 under section 21C of the NDPS Act. The gist of accusation is that, in this case, is that on receipt of information through reliable sources, a search operation was conducted and a vehicle bearing registration number ML01AC 8842 was intercepted. So the petitioners were found in the said vehicle. On the search of the said vehicle, the what was it? How much?
739.19 grams.
739.19 grams of suspected heroin
TFSL report is also there.
was recovered from the possession of the present petitioners. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail in this case mainly on the ground of violation of Article 22(1) of the Constitution of India. She submits that though the petitioners were served with the notice under Section 47 of the NDPS Act, however, the relatives, friends / nominated person by the petitioner were not served with any notice under Section 48 of the NDPS Act, in this case, 48 of BNSS. She submits that in pursuant to the observation made by the Apex Court in the case of Vihan Kumar versus State of Haryana, there is also mandate of furnishing grounds of arrest in writing to the relatives of the arrestee. Stop. On the other hand, learned Senior Standing Counsel DRI has countered the submissions made by learned counsel for the petitioner and has produced the case diary and has shown and has submitted that the notice under Section 48 of the BNSS was issued to the relatives of the petitioners on the date of arrest itself, and it was posted through speed post as the relatives were the inhabitants of the state of Manipur.
Lordship, in our bail objection, we have mentioned therein at page number 16, who has received a notice. For the accused number 1, his mother, namely Pari via speed post, who stays in Manipur, had received a notice. And for accused number
It is also submitted by learned counsel for the standing counsel DRI that the notice was received by one Shrimati Pari, who is the mother of the
accused number 1.
petitioner number 1, as well as for accused number
2, his family member Sri Light LAITHASAUNG via speed post. It is at page number 16, para number 9.
for the bail objection.
And the page number?
16. I'm sorry, Your Lordship, the running page, Your Lordship, I'm not, because it was filed yesterday. Not actually page number.
Of your objection?
My objection. Internal page 16.
You spell out the name.
Lordship, for accused number two,
Two
Sri Lalro.
has been received by his relative Sri Lalro. Spell out.
Received by Sri Laitha Saung, Laithasaung.
Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary which was produced by the senior standing counsel DRI. On perusal of the case diary, it appears that written notices under section 47 as well as 48 were issued in this case as mandated by Article 22 of the Constitution of India, and therefore apparently prima facie it appears that there has been no violation of said constitutional mandate. Moreover, as the quantity of contraband seized in this case is of commercial quantity, the embargo of Section 37 of the NDPS Act is applicable, which the petitioners have failed to overcome. For the aforesaid reasons, the prayer for bail of the petitioners is hereby rejected. Send back the case diary.
Petition was given the bar 174 days. Affair is page 11. After completion of the investigation, my lord, Mr. Agency committed charge sheet against the 6 accused persons, including the agent petitioner. And my lord, out of 23 witness, my lord, 5 witness already examined, my lord. W1 is the eyewitness, my lord, son of the victim, my lord. None of the witness, my lord, not investigating the present petitioner, my lord. And my lord, at the time of arrest, my lord, grounds of arrest not furnished to the petitioner, my lord, present petitioner, my lord.
Next question, Your Lordship.
Where is the FIR?
Page 11, my lord. May I read, my lord?
Whether somebody died.
My lord. But PW1 is the son of the deceased, my lord, victim, my lord. PW1 already examined, my lord. PW2 already examined. Already 5 witness already examined, my lord.
So here in this case, we have 5 witnesses examined out of 23. 23 numbers.
There are other material witnesses. How many?
Lordship. Here, 4 or 5 material witnesses are also there, Lordship. But Lordship, this person, as per the series, I have controlled the CD also because there's only 5 witnesses examined, and out of 3, the only 1 witness is the eyewitness, that is the son. But he has not indicated this person at the time of when they killed his father. But Lordship, the co-accused statements are there, Lordship, wherein they have stated, Lordship, that this person was there. They have they have made that conspiracy. They have made that plan to snatch the money, or if you get, they will kidnap his son, this eyewitness.
Apart from the eyewitness, you have some other evidence. Whether other evidence to implicate him, apart from the sole eyewitness. No, how will you ensure his conviction if there are? How will you prove charges against him? If eyewitness, apart from eyewitness, suppose you have nothing else.
Also, Lordship, the eyewitnesses also did not have not implicated.
And you don't have other witnesses.
Because it was in at the night time, Lordship.
Because co-accused are not going to depose against him.
Because in dark.
What is your name?
M.
No, the name of the
Abhijit Basmati.
Abhijit Basumatari. What is the accusation? He was involved in the conspiracy.
They all have come jointly, the car of that Abhijit Basumatari. But subsequently, they saw the thing that this car, because of this poor old car, they will not reach that person. So they have hired, they bring another car, Alto car, and they reach the spot. So, and he left here. He did not went to the spot.
He did not go to the spot.
Subsequently, when they snatch the money from that person, Lordship, and he has also get the share of it.
Yeah.
This Abhijit Basumatari has got 10 rupees from them.
Some evidence is there to prove that.
That is, Lordship, the co-accused statement is there. So many witnesses are yet to be examined, Lordship, and persons with some such kind of offenses involving such kind of witnesses also. That is the
yes. Who are yet to be examined? Who are those witnesses? Let 5 more independent witnesses be examined.
Noyan Wall is an eyewitness, my lord, informant. Dharmendra Rava, Mary Hazurike, Corbin Krishna Nath, and Goswami Rava will be examined.
Not in this stage. Heard Mr. M. Hawk, learned counsel for the petitioner. Also heard Mr. P. S. Locker, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Abhijit Basumatari, who has been detained behind the bars since 1/2/2025 within bracket for last 174 days in connection with sessions case number 127/2024 under section 126 within bracket 2, 3110 within bracket 3, read with section 25 within bracket 1 capital A/27 of the Arms Act, presently pending before the Court of Learned Additional Sessions Judge, Gwalpara. The gist of accusation in this case is that on 15/7/2024, one Shri Nayan Goyal had lodged an FIR before the officer in charge of Agya police station, inter alia, alleging that when the informant and his father were traveling from Rajapara to their house in vehicle number AS01FB 2205. They were intercepted by some 4 to 5 persons in front of Sholamari Kali temple, and one of the assailants shot gunfire at the father of the informant and looted a cash amount of 90,000 from them. Later on, the father of the informant was declared dead in the hospital. Learned counsel for the petitioner has submitted that the petitioner has been implicated in this case mainly on the basis of the statement of co-accused. He was not present at the spot where the offense was committed. Stop. He further submits that the petitioner has been languishing behind the bars for 174 days and only 5 of the listed 23 prosecution witnesses have been examined till date. He further submits that in this case, there is only one eyewitness, that is the informant Nayan Goyal himself, who has already been examined as PW1. He further submits that in his deposition as PW1 before the trial court, the informant has not implicated the present petitioner in the alleged offense. He therefore submits that considering the period of detention, the petitioner may be allowed to go on bail. Stop. On the other hand, learned additional public prosecutor, Mr. P.S. Locker, has vehemently opposed the grant of bail to the petitioner on the ground that the offense involved in this case is a serious offense which resulted in killing of the father of the informant. He, however, submits that though PW1 has not implicated the present petitioner, there are the other co-accused have implicated the petitioner in their statement, which were recorded under section 180 of BNSS. He also submitted that though the petitioner was not present at the spot, however, he took a share of the cash which was looted, and therefore he is equally liable for the offense alleged in this case. Stop. I have considered the submissions made by learned counsel for both these sides. Considering the fact that the present petitioner has not been implicated by the sole eyewitness who has already been examined in this case. Also considering the fact that the petitioner has already been detained behind bars for last 174 days and 18 more prosecution witnesses are yet to be examined, which would certainly take considerable period of time. Stop. The present petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Sessions, Learned Additional Session Judge Golpara, with following conditions. Two conditions, trial conditions. This bail application is accordingly disposed of.
Item 23.
Lordship, I have take the competition and also Lordship, I'm referring a Lordship's order.
How long you were behind the bars?
Lordship,
That
Yes.
was the query.
yes, that query is 1 year, 5 months, 21 days. This is the order, Lordship, I am referring on the same stand. Lordship has my sole ground in the instant petition is that Lordship violation of Article 22(1), and the notice I have annexed in this petition at page 15, Lordship. That page 15 of my petition, Lordship.
Where is the notice?
Notice page 15, Lordship, Annexure 3. I have also certified copy with me. And apart from the sympathetic ground that he is a man of 73 years old and suffering heart issues, Lordship.
No sympathy.
That
In
is why,
NDPS.
Lordship, yes,
Yes.
Lordship. So page 15, I have a certified copy of.
What is date of your arrest?
My date of arrest is, Lordship, 4th of February 2024. And after Pankaj Bansal's
What was the date of judgment of Pankaj Bansal?
3/10/2023, Lordship.
Yes, what is the submission?
Yeah, in this case, Lordship, section 50 CRPC notice. That is at page 15, Lordship. That is dear Lordship.
That is what I have served with Lordship. And this is the certified copy, Lordship. That is my case, Lordship.
So, Lordship, this is section 50 CRPC notice. It has been stated, Lordship, that you are hereby informed that you have been arrested in connection with the above reference case. The section of the law of the case are not available for police, hence needed to be arrested and will be forwarded to the honorable. Can move to bail before the honorable court. So, Lordship, this is the section 50 notice, Lordship, and ground of arrest, Lordship. And but the Granite Council for the petitioner is submitting, Lordship, this is not the ground of arrest, Lordship. The ground of arrest is not elaborately mentioned here. On earlier occasion also, I have submitted, Lordship, when the ground of when person is caught red-handed. The ground is the reason and ground why he has been arrested is fully known to him, Lordship. And in regarding the violation of Article 22(1), Lordship, Lordship may kindly see one thing, Lordship, that Lordship, in Article 22(1) also, Lordship, this is not the only criteria that Article 22(1) has to be fulfilled, Lordship. That on the ground of arrest has to be furnished to the accused petitioner, arrested person. There are some other criteria, Lordship, which is to be fulfilled, Lordship. In Bihan Kumar case, Lordship, may kindly see Bihan Kumar case, please.
Bihan Kumar. Yes.
Bihan Kumar case, Lordship, para 9, Lordship. Para 9.
Yes.
Article 22 of the Constitution reads as Article 22, protection against arrest and detention in certain cases. 1, which is relative nowadays. No person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So, Lordship, here in this case, Lordship, the first part, if you though they are not admitting, no, they are that this is not the ground of arrest, Lordship. Even if for a time being, Lordship, it is admitted, Lordship, that this is the ground of arrest. Section 50 is a ground of arrest. Then the second part, then there comes the second part, Lordship. Because, Lordship, after that, Lordship, they have engaged their counsel in the court below order, Lordship. It is stated, Lordship, that they are going to appoint their counsel of his choice. It is reflected in the order, Lordship. So, Lordship, it is not like, Lordship, the entire Article 22(1) is being violated, Lordship. When
Something is violated.
something is not violated. Why I am saying, Lordship? Because of subsequent order, Lordship, we have, Lordship, may kindly para 13, Lordship. Para 13, Lordship. In the case of Lallu Bhai, Jogi Bhai Patel versus Union of India, in paragraph 20, this court held as 20. It is admitted position that the detainee does not know English. The ground of detention which were served on the detainee have been drawn up in English. It is true that Sri C.L. Adali, police inspector who served the ground of detention on the detainee, has filed an affidavit stating that he has fully explained the grounds of the detainee in Gujarati to the detainee, but that is not sufficient. Compliance with the mandate of Article 22(5) of the Constitution, which requires that the grounds of detention must be communicated to the detainee. Communicate is a strong word. It means that sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. Now, Lordship, the whole purpose of communicating the ground to the detainee is to enable him to make a powerful and effective representation. If the grounds are only verbally explained to the detainee and nothing in writing is left to him in a language which he understands, then that purpose is not served. So the only purpose here also, it is also the only purpose is so that he can engage in strong representation before representation also. That there regarding that part, remaining part also. They have the Lordship can skip.
No, I have not understood. You want to say that if the accused engages a counsel, then it is not material whether grounds were communicated in writing or not.
Whether grounds are fully grounds are communicated to him, that is not because Lordship,
That is not material.
not material. Because Lordship, why Lordship? Because
The purpose is to engage a counsel. As counsel has been engaged, therefore, the requirement of furnishing grounds of arrest may be waived.
Even in Bihan Kumar case, Lordship, that was not given. No section 15 of this, no section 47 notice was furnished to him, Lordship. If only the IODS text was taken, Lordship, that they have by way of filing, they have informed that that has been communicated to him, Lordship. Therefore, Lordship can kindly come to the second paragraph, Lordship. That paragraph 13, second paragraph.
Of Vihan Kumar.
Vihan Kumar, Lordship. Paragraph 13. Just now I was written.
Yes.
That after skipping 4-5 lines, Lordship, however, Lordship will find Lordship. However, Lordship got it.
Now you read, I am listening.
However, under Article 22(1), there is no requirement of communicating the ground of arrest in writing. Article 22(1) is also Article 22(1) is also incorporates the right of every person arrested to consult an advocate of his choice and the right to be defended by an advocate if the ground of arrest are not communicated to the arrested as soon as may be. He will not be able to effectively exercise the right to consult an advocate. So here also in Bihan Kumar the judgment, so it has been opined.
This is not a way to read the judgments. Picking and choosing. What is the conclusion of the Bihan Kumar?
Then let's kindly come to the conclusions also. Para 21 also. Para 21 also.
Para?
21. That is the conclusion of the document.
Which, which citation you are reading? 225 SCC online. Vihan Kumar Arwe eta ase noy.
I am to 2025 OCC online 269.
Yes, what, para 21, what you want to say? Yes. Yes, please read. Read the relevant portion on which you are relying, which helps you.
This is the only short paragraph, para B, 21B. The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The second line I am relying that the mode and method of communication must be such that the object of the constitutional safeguard is achieved. The mode and the method of the communication must be such that the object of the constitutional safeguard is achieved. What is the constitution? What is the mode and method and constitutional method? Lordship, that is Lordship object. That is Lordship may kindly come to the last paragraph, Lordship. And just Honorable Mr. Justice N.K. Singh's judgment, Lordship, para 3. Para 3, the last page, Lordship, may kindly come to the last page.
Yes.
Okay. Also, therefore, after skipping 2-3 lines, Lordship may kindly come to see also therefore.
Yes.
Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives as mentioned above is not merely a formality, but to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or nominated persons to secure his release at the earliest possible opportunities for exercising the fundamental right to liberty and life as granted under Article 21 of the Constitution of Constitution. So now everywhere it is stated, Lordship. In Lordship, one more thing, Lordship, I would like to last Lordship, may kindly come to para 31, Lordship. That is also related to our case also.
Yes.
The learned single judge unfortunately has equated information given regarding the appellant's arrest with the grounds of arrest. The observations that the allegation of non-supply of the grounds of arrest made by the appellant is a bold allegation is completely unfair, uncalled for. All courts, including the high courts, have a duty to uphold fundamental rights. Once a violation of a fundamental right under Article 22(1) was alleged, it was the duty of the High Court to go into the said intention and decide in one way or the latter. When a violation of Article 22(1) is alleged with respect to grounds of arrest, there can be possibly two contentions raised. The first, A, that the arrested person was not informed to the grounds of arrest. B, purported information or grounds of arrest does not contain any ground of arrest. As far as the first contention is concerned, the person who is arrested can discharge his burden by simply alleging that ground of arrest were not informed to him. If such an allegation is made in the pleadings, the entire burden is on the arresting agency of the state to just satisfy the court that effective compliance was made with the requirement of Article 22(1). Therefore, the view taken in the High Court is completely erroneous. But Lordship, here in this case, Lordship, regarding the second part, which nowadays we are following, Lordship, that the purported ground of arrest is there, but there is no any ground of arrest. Regarding that, there is no any discussion, Lordship. We have not found any discussion regarding that, Lordship. So, Lordship, when there is no any discussion, Lordship, Lordship may interfere in that regarding that part, Lordship. That Lordship, whether that is whether this purported, even though it is stated that it is a purported, Lordship, whether this is sufficient for them to know the ground of arrest when persons are caught red-handed, Lordship. And because of Lordship, at the same time, we have to check the balance of the right of the society also. That is also mentioned here in this case, Lordship. That is also, Lordship, we kindly come to paragraph.
Okay, enough. Anything else?
There are some other judgments, Lordship, I have to, but today I am not available because
Just finish, then I can just.
that is why I'm paying actually in the first of all, I'm paying for fix it on Monday, Lordship, so that I can, even as I am preparing that written submission also, Lordship, so that Lordship can fix it on Monday. Then other
Lordship,
judgments will also come.
here, Lordship, what he has stated, to my understanding,
No, this has to be addressed.
yes, Lordship, that I am answering, Lordship, while he opposing, he has defended me, Lordship, because all the statement he has made that is in my favor, there has to be elaborate written statement. Here, Lordship, if your Lordship takes up page 15, here case number has been cited, that about my name and address has been shown, and you are hereby. Where, Lordship, grounds of arrest? What he is defending? He is defending me only, Lordship. That para 9 he is quoting, that para is in my favor, Lordship. That is absolutely in my favor. That has to be there. He's trying to interpret that. Now hundreds of persons has
Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. This application under section 482, 483 of BNSS has been filed by the petitioner, namely Mohammad Fazlul Haq, who has been detained behind the bars since 4/2/2024, within bracket for last 1 year, 5 months, for more than 1 year, 5 months, in connection with special case number 447/2024 under section 22C/29 of the NDPS Act. The gist of acquisition in this case is that on 4/2/2024, one Kapil Chandra Das had lodged an FIR before the officer in charge of Dhubri police station, inter alia, alleging that on receipt of an information through reliable sources that large number of narcotic substance have been kept concealed in the house of one Nayan Chandra Nath at ward number 15 of Dhubri, a search team was constituted and a search operation was conducted. Stop. During the search operation, what was the recovery?
some cough syrup, few bottles of cough syrup, Lordship. 12, Lordship.
30
numbers of
30 numbers of bottles of cough syrup containing codeine and 250 numbers of stripes of Pivon Spas Plus capsule containing tramadol, as well as 140 numbers of nitrazepam tablets were recovered from the house of said Nayan Chandra Nath. How Faizul Haq is involved?
Lordship, he happened to be a guest on that particular day from the, on the.
At the time of search, at the time of recovery of the aforesaid contraband, the present petitioner was also found at the place of recovery. Stop. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for more than 1 year, 5 months. And what is the status of the trial?
Out of 7, Lordship, 3 has been examined.
And the trial has not progressed much. She submits that out of 7 listed prosecution witnesses, only 3 have been examined till date. She also submits, the learned counsel for the petitioner has also submitted that the petitioner is a aged person of 72 years, which may also be taken into consideration while considering the prayer for his bail. Stop. She further submits that the petitioner has mainly approached this court on the ground of violation of his fundamental rights guaranteed to him under Article 22(1) of the Constitution of India, as at the time of the arrest of the present petitioner, the notice which was served under Section 50 of the CRPC does not contain any grounds of arrest. She submits that the notice which was served on the petitioner at the time of his arrest only contained the information regarding the police station case which is involved, that is Dhubri PS case number 34/2024, as well as the penal provision involved in the case, that is offense under section 22C/29 of the NDPS Act 1985. She submits that apart from the aforesaid facts, no grounds or no basic facts which necessitated the arrest of the petitioner was mentioned in the said notice. She also has relied on the ruling of the apex court in the case of Vihan Kumar versus State of Haryana and another, wherein the apex court has observed that at the time of arrest of the arrest of an arrestee, it is the mandate of Article 22(1) of the Constitution of India to furnish grounds of arrest, in writing, to such an arrestee. Stop. She submits that if there is a violation of this mandate, it renders the arrest itself illegal, and on that count, the petitioner is entitled to get bail. You are relying on any other judgment?
Yes, Lordship, Prabir Kumar Purokar.
The learned counsel for the petitioner has also relied on the judgment of the apex court in the case of Prabir Purkayastha versus State within bracket NCT of Delhi, reported in 2024 8 SCC 254, wherein the apex court also observed that the grounds of arrest to be furnished to the petitioner at the time of his arrest is a mandatory constitutional requirement, and any deviation from the same would vitiate the arrest stop. She therefore submits that, as in the instant case, the notice which was furnished, which was served on the petitioner, does not contain any grounds of arrest. The petitioner is entitled to get bail in this case on that count only. Stop. Next para. On the other hand, Mr. P.S. Lakar, learned counsel, learned additional public prosecutor, has vehemently opposed the grant of bail to the petitioner on the ground that the quantity of contraband recovered in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable to this case. He also submits that in this case there is no violation of the constitutional mandate of Article 20, Article 22(1) of the Constitution of India. Referring to the judgment of the Apex Court in the case of Vihan Kumar versus State of Haryana and another within bracket Supra, he submits that the purpose of the inclusion of provision of furnishing grounds of arrest to an arrestee at the time of his arrest in Article 22(1) is to enable him to engage a counsel so that he can properly defend himself. And once the said purpose is achieved, it cannot be said that there has been any violation of the constitutional mandate of Article 22(1) of the Constitution of India. He also submits that
At the same time, when there is a section 50 notice is there.
he also submits that in this case, section 50 notice has been served on the petitioner, which was also on which the petitioner also had acknowledged, which the petitioner has also acknowledged by putting his signatures thereon. And as the service of section 50 notice is not disputed, there is no violation of statutory provision of section 50 of the NDPS Act of the BNSS, as well as constitutional mandate of Article 22(1) of the Constitution of India. He also submits that in this case, the petitioner was arrested at the time of recovery of the seized contraband red-handed from him. He also submits that in a case where the petitioner is found, when a petitioner is caught red-handed with the seized contraband, there is no requirement to punish him separately the grounds of arrest, as the reason for arrest is well known to him. Anything else?
Relying on the Kumar judgment, that para 13, para 15, and 21.
What?
Regarding in para 13, Lordship, that is the purpose is mentioned.
That I have dictated.
Then in para 15, Lordship, that in para 15, Lordship, it is Lordship, that there is a observation Lordship, that the police have to balance the right of a person arrested with the interest of the society.
Learned counsel for the petitioner, learned additional public prosecutor has also submitted that as the offense under NDPS Act is a heinous offense, which has a negative impact on the society, the rights of the individual has to be balanced with the rights of the society.
Mentioned in para 15.
Stop. I have considered the submissions made by learned counsel for
Para 21 also, Lordship, that is the purpose is cited also.
that I have dictated. And I have considered the submissions made by learned counsel for both the sides and have gone through the scanned copy of the records of special case number 447/2024. On perusal of the records, it appears that on perusal of the copy of notice under section 50 CRPC, which was served on the petitioner, in this case, it appears that it contains the reference of the Dhubri PS case number 34/2024, as well as the penal provision under section 22C/29 of the NDPS Act. It also contains an information that the petitioner is arrested in connection with the above referred case, and which is non-bailable in nature. It also contains an information that the petitioner, after his arrest, would be forwarded to the court and he can move a bail application before the said court. Apparently, apart from the police station case number and the penal provisions, there is no other indication as to what required the arrest of the petitioner in this case. Bare perusal of the notice would reveal that no basic facts which necessitated the arrest of the petitioner has been mentioned in the said notice. This notice can very well be interpreted as an intimation to the petitioner that he has been arrested in connection with Dhubri PS case number 34/2024 in connection with an offense under section 22C/29 of the NDPS Act. Nothing apart from that fact can be discerned from the said notice as to how the petitioner is involved in the aforesaid case or what is his role could not be gathered from the facts, from the information which is there in the said notice. the apex court in the case of Vihan Kumar versus State of Haryana has Kaliga. No. The apex court in the case of Vihan Kumar versus State of Haryana has observed that has observed as follows. Code para 26.1 to 26.6 from the said judgment. Thus, from above, it appears that the information regarding ground of arrest to an arrestee must be provided to him in a manner that sufficient knowledge of the basic facts constituting the grounds are imparted and communicated to an arrested person. It also appears from above that any violation of the aforesaid requirement would render the arrest of an arrestee itself vitiated, and on that ground an arrestee may be granted bail on that count itself. The submission of learned additional public prosecutor that as notice under section 50 has already been furnished in this case. Hence, there is no violation of the statutory provision of section 50 as well as Article 22(1) of the Constitution of India cannot be accepted as unless the notice contains the basic facts which necessitated the grounds of arrest, which necessitated the arrest. No, ये line तो पढ़ो. Necessitated the arrest of the petitioner. It may not even be regarded as a notice under section 50 of the CRPC, though it purports to be so. Stop. regarding the submission that when a person is arrested red-handed with a contraband, he is aware about the facts for which he has been arrested, and therefore there is no necessity of furnishing any grounds of arrest to him separately, is also not acceptable, as such an interpretation would tantamount to diluting the constitutional requirement of furnishing grounds of arrest in writing to the petitioner as interpreted as provided under Article 22 of 22(1) of the Constitution of India and clarified by the Apex Court in the case of Vihan Kumar versus State of Haryana, as well as Prabir Purkasta versus in City of Delhi. In the case of though societal interests as well as right of an individual are to be balanced, however, in the garb of protecting societal interests, when offense of serious nature under under NDPS Act is involved, the police does not get a license to violate mandatory constitutional norms on their sweet will. Any attempt to encroach upon the constitutional right, upon the fundamental rights of individual which are protected by Constitution of the India, has to be looked at very seriously. This court therefore does not agrees with the submissions made by learned additional public prosecutor that in cases where the petitioner is caught red-handed, there is no requirement of furnishing written grounds of arrest separately. As already said earlier, such an interpretation would amount to diluting the constitutional mandate provided under Article 22. No interpretation, no interference. Stop. In view of the discussions made herein above, this court is of considered opinion that in the instant case also by serving a bold notice on the petitioner, which purporting it to be a notice under Section 50 of the Code of Criminal Procedure 1973, the arresting authority has violated the fundamental rights of the petitioner, which are guaranteed to him under the Constitution of India. Hence, on that count itself, the petitioner is entitled to get bail. For the reasons stated, for the reasons mentioned in the foregoing paragraphs and the discussions made herein above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned special judge, where
Dhubri, Lordship. Special judge.
learned special judge Dhubri, with following conditions. Take trial conditions from Abhishek. This bail application is accordingly disposed of. You can still give your written objection on Monday.
So here one sort of my prayer Lordship, that I have not my submission is not that Lordship that written ground of arrest is not required. My submission was that Lordship when person caught red-handed that section 50 is sufficient Lordship. Lordship. I cannot say Lordship that is not required. I cannot say Lordship. That is sufficient because because in para 21 also itself says Lordship that the modern method.
No, but section 15 notice here does not contain. Your submission is that
it is sufficient Lordship to know the ground of arrest. Because he has been caught red-handed Lordship.
if somebody is caught red-handed, then what is the submission?
Lordship, in that case, Lordship, this section, this in this format, the section notice is sufficient to know why he has been arrested, Lordship. On what ground he has been arrested, Lordship.
Grounds are not there in the 50 notice.
When it is stated Lordship, that the modern method of communication must be such that the object of the communication safeguard is assured. That a modern method may be different, Lordship. In some cases, there may not be that will not come. When person is in UAP Act, Lordship, the person is caught red-handed.
No. You clearly mention about your submission. What do you want to submit?
Yes.
If a person is caught red-handed, then
this time the present format of section 15
is sufficient.
is sufficient
Okay.
to know that why he has been arrested
Okay.
on what ground he has been.
Okay. এটা paragraph এইটো পিছত add কৰিব লাগিব. Learned counsel for the learned petitioner, learned additional public prosecutor has submitted that when a person is caught red-handed, the furnishing of section 15 notice to him in the manner in which it has been furnished in the instant case is sufficient compliance of the constitutional mandate. I
cannot say that.
No, you can say, lawyer can say anything, because only then law will develop. There is no, suppose apex court says something, lawyer is not prevented. He can say, only then it will be, law will develop. Yes, next.
Item 25. I'm sorry, Lordship. I was in another court. Lordship, this is
আমার কেস citation বেলেগ কে রাখি item number yes Mr. Munir.
This is Lordship recovery of 21.605 kg of ganja, Lordship. And the sole ground, Lordship, that non-furnishing of ground of arrest, Lordship, as well as not furnishing the section 50 notice, Lordship. 47 and 48 has been served upon us, Lordship, without furnishing the ground of arrest, and 50 was not served.
Where are the notices?
Notices, Lordship, can find on page 24. It's a certified copy, Lordship, page 24. Page 47 and page 25 is the 48, Lordship.
Same.
Okay, but the thing is there. And one more thing, Lordship, regarding section 50, Lordship, that Lordship will find from the forwarding report that page 23. Page 23. Page 23, no mention about the notice under 50. And
And thereafter the order passed by the magistrate lordship. Here is the page number about. Next for next for
Yes, Mr. Das, what is your submission?
It is there, lordship. In regard to section 50, lordship, when it is not found in the body, lordship, it is not in the body. The search is not in the body, lordship. Physical search is not there. So section 50 is not needed, lordship. That's not the grounds of arrest, lordship. Grounds of arrest is there, lordship. Grounds of arrest আছে আমার কিন্তু সার্টিফিকেট কপি দিয়েছেন আমি তো দেখা পাবো না কপি সার্টিফিকেট কপি দরকার নাই স্যার
Whether arrest memo is served on the,
lordship, it is there.
no. My query is, at the time of arrest, you prepare an arrest memo also, arresting authority prepare an arrest memo. 47 notice and 48 notice. 47 and 48 is furnished to the arrestee and his relatives. But arrest memo, whether it is furnished,
Arrest memo is there, lordship.
no, it is there,
Lordship.
but whether it is served on the PT.
Signature is there, lordship. The arrested person's signature is there. Her name is Amina Khatun, and it is there.
No, have you served a copy of this notice to the copy of arrest memo to the petitioner?
Lordship, signature is there, lordship. But I don't know whether it is submitted to them or not, but it is there.
No, the requirement is of furnishing the grounds of arrest in writing.
It is in writing, lordship. No, enclosure, lordship will kindly see, lordship. Page 23, lordship. Enclosure has been made, lordship.
No, whether my query to both of you is whether arrest memo prepared at the time of arrest, whether a copy of that is furnished to the arrestee at the time of arrest. Is it required to be furnished, or if it is only required to be kept in the records? Suppose you mention grounds of arrest because you, while in the forwarding report to the magistrate, you mention grounds of arrest. So magistrate is communicated with the grounds of arrest. Requirement is to communicate the written grounds of arrest to the arrestee. If you prepare grounds of arrest, mention grounds of arrest in the arrest memo, and keep the same in the records without giving a copy of that to the petitioner, will it be compliance of? Yes or no? Then it is only in the case diary.
I don't know whether it is submitted to arrestee or not.
Now, they are stating that they received only
These two
notice under 47
But the
and
sign is there. At the time of arrest, all good citizens are also everywhere. Who will argue with the policeman?
no. What is required? What is the requirement? Requirement is of furnishing What is this? No, arrest memo is there. My query is arrest memo is there in the records. Yes, that is the requirement. No, signatures are also there. Suppose you take signature of the arrestee in the records without furnishing a copy of the same to him. Will it be compliance of section? No, burden is on you. You have to say that I have fun.
That they have been submitted or not, because it is not CD, in the CD it is not written. But
Then from whom you will take instruction? That is not my query. Requirement is of furnishing a written grounds of arrest. Suppose you prepare grounds of arrest, take his signature, keep it with the record without furnishing a copy thereof. And requirement, you will not furnish a copy of the arrest memo because you have already furnished 47 and 48 notice to the Yes, Mr. Munir.
Actually, my ground would be that 47 and 48 lordship, that there are no grounds of arrest, lordship, other. Which I have annexed copy is a certified copy lordship, where it reveals that no grounds of arrest were mentioned.
Mr. Das, what prevented the arresting authority to mention the grounds which you have mentioned in the arrest memo in detail? Same in the notice under section 47.
in the, when the ETC was forwarded to the magistrate order, then it will be seen that whether 47, 48 has been given or not.
No, 47, 48 has been given, but it does not contain grounds of arrest.
In the CD lordship, it is there.
In CD, you can keep everything without informing the petitioner. The requirement is to communicate it to him.
Fix it on Monday lordship then.
What will you say on Monday?
I will call the IO lordship.
What I will do? And I cannot say out of his memory what is there. It will be there in the case diary. If I can go through case diary, you can also go
I will
through.
look into Monday
Okay.
then lord.
Okay, let him go through. My query is keeping arrest memo in the case diary is wherein you have mentioned detailed grounds of arrest. Is it the compliance of the requirement of section 50 and section article 22(1)? Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner has prayed for bail in this case mainly on the ground that the grounds of arrest were not communicated to him in the notice under section 50 of CRPC
No, 47 and
or 47 of
47.
BNS as well as 48 of BNS, which were served on the petitioner and his relative. So, on the other hand, learned additional public prosecutor submits that in the arrest memo prepared at the time of the arrest of the petitioner, which contains the signatures of the petitioner, detailed grounds of arrest were mentioned. A query was posed by this court as to whether a copy of arrest memo was furnished to the petitioner at the time of his arrest. To answer this query, the petitioner learned additional public prosecutor seeks some time. The prayer is allowed. Let this case be listed on Mondays 28.
Monday lordship, let it be on,
On Wednesday, 29, 30, 37.
Okay. Much obliged.
Item 34.
May I please, Your Lordship, in this case, CD was called for, my lord. Petitioners are behind ever since 37 days, my lord. The allegation is that
34 and 63 is similar, Lordship. It may be called together.
62, Debo.
63, Lord.
63. What is the offense?
offense is, my lord, some culprit, my lord, to put skull of cow, my lord, in front of number, my lord. And
Treasurer is there.
petitioner are arrested only on suspicion that they may be put the skull, my lord. And some old skull recovered from their backyard of the house, my lord. Because after Eid, my lord, they have put it backyard in house, my lord.
What is the FIR? Let us go.
FIR is on page 10, my lord.
Read it, please. Read the relevant part.
With
Wow.
regards to the cited above, I have the honor to report that yesterday on even around 11 p.m. while N.K. Rehan Payang with the staff of Panigaon PS were executing night patrolling, they received an information over phone that some unknown culprit have kept skull of cow in front of Kuakhania Siding Suk Namghor. Accordingly, as instructed by Superintendent of Police Lakhimpur, self proceeded to the spot and recovered 3 numbers of suspected skull of cow, which were accordingly seized as per the seizure list. Sources revealed that the following person, namely Mansur Ali, son of so-and-so, village so-and-so, do number MD Rezek Ali, son of so-and-so, village so-and-so, third Saha Ali, son of so-and-so, fourth Dilwar Hussain, son of so-and-so.
Who are you?
My lord, I am my lord Mansur Ali, 4 person, my lord.
Rezak Sahali. And
Rezak Ali, all are
what are the material against them? They are arrested. When were you arrested?
We have arrested my lord on 18/6, my lord.
What is your submission?
Already behind about 37 days, my lord. And merely on suspicion, we are arrested, my lord. We are not involved in this case, my lord. And regarding the, my lord, skull recovered from our position, my lord, in backyard of our house, my lord, after it, my lord, we have put it there, my lord, because after Kurbani.
Yes.
Yes, Lordship. Firstly, I want to stress on the point that, Lordship, 299, 196 and are added, and 196 is also there. This relates to, Lordship, deliberate and malicious act intended to outrage religious feelings.
No, it is there.
It is there,
It is there.
In
The query is,
Lordship.
how is there any material to show that they are involved? Otherwise, the offense is serious.
Definitely, Lordship. What I have found in the CD, Lordship, is that one seizure is there in which in front of the Namghar, Lordship, this 3 numbers of cow skulls are there. And another seizure is there, Lordship, where I have found, Lordship, the 3 number of suspected skulls of cow were also found in these 3 persons, Lordship. The petitioner 1, 2, 3, that is item number 34 is there. And they are in their, from their statement, it is come to ascertain that they were also doing this business of illegal cow slaughtering. They themselves stated that, Lordship, and they have no permission is there, no license are there with them. Only these things is there, Lordship. These two things I have found, Lordship. Firstly, one
But
recovery of
who
there.
put the
Oh, that is not there, Lordship.
skull? That is not there.
Lordship, it is not there. But these 2 things are there.
Heard Mr.
M. Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Mansur Ali, number 2 Muhammad Rezak Ali, Saha Ali, and Dilwar Hussain, who are detained behind the bars since 18/6/2025 within bracket for last 37 days in connection with Panigaon PS case number 37/2025 under section 61 within bracket 2 within bracket small a slash 298/299/196 2 slash 329 3 slash 3 within bracket 5 of BNS read with section 313 of the 13 within bracket 1 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 17/6/2025, who lost the affair?
Fair Lord, by the police officer in law. Himanta Pathak, SI.
One
Himanta Pathak, SI, my lord.
Sri Simantak Pathak, SI of police, lodged an FIR before the officer in charge of Panigaon police station, inter alia, alleging that during night patrolling by police in the area under Panigaon police station, it came to notice that some unknown culprits have kept skulls of cow in front of Dhokwa Khania Siring Suk Namghar, and the names of 7 accused persons and 7 accused persons who are named in the FIR were suspected to be involved in the said offense. You are named in the FIR?
Yes, ma'am.
The petitioners are also named in the FIR. The learned counsel for the petitioner has submitted that the petitioners are in no way involved in throwing of cow skulls in front of the Namghar as alleged in the FIR. He submits that as the petitioners are Muslims by religion, after the Eid no, he line to continue. The petitioners are, the learned counsel for the petitioners have submitted that the petitioners are arrested merely on the basis of suspicion, and they are languishing behind the bars since for last 37 days, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that the offense alleged in this case is of serious nature, as there was an attempt by the miscreants to incite religious hatred among the group by throwing skulls of cow in front of a Namghar. He, however, submits that the investigation has not yet revealed, investigation conducted till now has not yet revealed as to who have kept the skulls of cow in front of the Namghar. However, he submits that in a different recovery, skulls of cows were recovered from the compound of
this Mansur Ali, and these 3 persons are also there. Petition
From one Mansur Ali
and other 3 persons are there.
and
Reza,
the
Saha.
Mansur Ali and other petitioner from the house of the petitioners. Stop. He therefore opposes the grant of bail to the present petitioner at this stage. I have considered the submissions made by learned counsel for both sides. Though from the materials in the case diary, it appears that there is a strong suspicion regarding involvement of the present petitioners in the offense alleged in the affair. However, even after lapse of 37 days during which the petitioners were detained behind the bars, the said fact still remains in the realm of suspicion only. Stop. The suspicion, howsoever grave, cannot take place. May not substitute the concrete evidence which is lacking at this stage. Stop. Considering the fact that the petitioners have undergone the detention of 37 days, which in the considered opinion of this court is sufficient to subject them to any kind of custodial interrogation if same was required. Stop. This court is of therefore considered opinion that if the petitioners cooperate in the investigation, their further custodial detention may not be necessary. Hence, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned, whose
CGM, not Lakhimpur.
Chief Judicial Magistrate Lakhimpur, North Lakhimpur, with following conditions, number 1 and number 2. Next case is same case.
Is of the same, my lord, only where nothing has been recovered from my position.
Heard Mr. H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application has been made by the made under section 483 of BNSS by the petitioner Dildar Hussain, who has been detained behind the bars in connection with behind the bars since 18/6/2025 in connection with Agor case logot ekek. Everything will remain same. One submission. Agor case logot eke thakibo. Petitioner submission eta add koro. Learned counsel for the petitioner has submitted that nothing was recovered from the possession of the present petitioner. Other things will remain same.
Only thing is that Lordship, why he is arrested, in his house nothing has been found, but he is doing a business of this illegal slaughtering of cows. That is right.
Learned additional public prosecutor submits that though nothing was seized from the possession of the present petitioner, however, there are materials to indicate that the petitioner has been indulging in illegal slaughtering of cow in violation of the provisions of Assam Cattle Preservation Act 2021. Baki eke takibu 30,000 vita.
Item 35.
May I please your lordship, is a 483 application, my lord. what happened, he was arrested on 18 to 25.
Could-
While he being a mechanic of a garage, while he was making trial of the truck, some white cloth police went to his garage roadside and wanted to verify the truck, my lord. He said, yes, you're welcome. What do you want to say, see? Then they have brought out some, my lord, 2.97 Yavo tablets from some chamber of the said truck. 97 Yavo tablets.
KG, my lord.
kg. So, my lord, he was taken to the custody, but the fact remains very mysterious. The garage owner, the owner of the truck, they ought to have been asked why they have kept the truck inside the garage and how. When he was arrested, man, he was brought to the before the special judge, and special judge has recorded his statement. I do not under what provision. And special judge has given a reasoning that yes, he admitted that he just stood up class. He was studying at night. He was doing mechanism in this garage mechanic. He is aged about 18 years, and he has allowed this vehicle to be searched. And then thereafter, those contrabands were recovered from the truck. Now, Maran, I am not the owner. I am not the garage owner. I am just a mechanic of the garage. Then, Maran, I am spending behind the person 18.3. Now, Maran, while arresting, 47, 48 were not complied with. Now, it has been proved from their own affidavit that they have not applied. I am taking out your lordship, minute. One thing, please come to page 66, minutes. Of their affidavit, my friend has submitted.
66.
66.
There is no 66.
Annexure or objection, my their affidavit. The affidavit filed by my London friend from DRI.
Where is it?
My page 66, annexure 1.
Section.
98.
There is no affidavit.
Affidavit.
When have you filed?
Long ago. I'm giving something.
Page 66. 66.
66. I'm giving.
There is no office note regarding objection.
But they have served us, my lord.
Sir, we filed it, my lord. We have the receipt.
They filed long ago. But that is 66, your lordship will find. That is the 47 notice.
This is not a 47 notice, my lord.
This is what?
This is a certificate. He has given undertaking. He has called his father. The arrest memo is on behind is that, my lord.
You have written. You have written. You have written in your
affidavit. You cannot say that.
You have written in your affidavit.
We have written it.
Yes, you have written in your affidavit.
I have not written like that.
What you have written? You see?
No, I have not.
What you have written first, please? Yes, what you have written? 66, what you have written?
I'll defer this matter.
No, my lord, kindly take.
You argue amongst yourself and
No, Your Honor. In the index, it is written the copy of acknowledgement sending information ground to arrest by the arrestee to his father over phone.
It
is a letter of the informing over phone. And you can come to, Your Honor can come to page number 75. Is the arrest?
no, that objection is not on record.
Yes, Your Honor.
That has to come.
He has come with a very totally different story that he is a student, he is a mechanic.
It is a district special judge said, not my opinion, brother. Not my opinion. You go through the record.
He said that he is driving a truck, he is driving a truck, everything is fake.
I was on trial.
In page 46, everything details is there.
Yes,
Okay,
you see.
heard Mr. A.C. Vishwas Lanet. We are directing the objection to be placed on record. It is not there. Heard Mr. A.C. Vishwas Lanet, counsel for the petitioner. Also heard Mr. What is your name?
M.K. Boro, my lord.
M.K. Boro,
Senior Standing Counsel.
Senior Standing Counsel, DRI, who submits that the DRI has submitted written objection against the application for bail filed by the petitioner. However, same is not there on record. He produces an acknowledgement. You have that acknowledgement of filing. When have you filed?
25/6/2025.
And submits that he has submitted the written objection. He has filed the written objection on 25/6/2025. The ইয়াৰে এটা ফটোকপি ইয়াত ৰাখি দিব, ফটোকপি এইটো ঘূৰাই দিয়ক. The registry is directed to verify and place the written objection filed by the DRI.
CD is here.
That we will retain DRI before in the case record before the next date fix. When can we fix it? Ito ghurai diyo. Let this case be listed again on
Monday, but
1st of August. Wednesday.
it is behind the bar. Anyway,
Wednesday.
if possible, 30th or 31st,
No, let me on Monday, madam, because I will out of motion.
Monday if possible. আপনি না থাকে নাকি? Monday না থাকে নাকি?
Next item.
Item 26.
Monday না থাকে নাকি? এতে নাকি?
First of August.
Hello, bhai.
As per the office note, service
It is a POXO case.
The CD also notice and service everything.
the petitioner is behind the bar for last 7.
There is allowed. Let this case be listed on
Lordship, kindly fix it on next week. He is behind the bar for last 73 days.
7th of August.
Item 37.
37 also CD notice, I was seeking another date number.
My lord, 60 days offense, my lord. This is second time, my lord. I am behind the bar since 50 days, my lord. The offending post has already been seized and recovered, my lord. So further custodial may not be required, my lord.
What is the offense?
My lord, offense is under section, my lord, 196 to 99, 302, 351, 352, 353 of BNSS. My lord, it is section 67 IPA. So far the offense is under section BNSS not yet committed, my lord. So far the IPA, my lord, first conviction is available, second conviction is, my lord, non-available.
When can you produce? Short date. First of August. Heard Mr. A. Parmanik, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks some more time for producing the case diary. Prayer is allowed. Let this case be listed on 1st of August.
38. Highly obliged.
Charge sheet submitted. POXO. Appear before the trial court.
I only pray one thing, submission will be recorded. The alleged victim girl, she's 17 years, 11 months, man. And the accused petition for lordship, he's 18 years, man. There is around 46.
An additional public prosecutor who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 1st of August.
I lived.
Item 40.
My lord, 483 bail application.
What is there?
They have not taken steps.
Steps have for issuance of notice.
23/7/25.
You have not taken steps for issuance of notice.
We have given extra copy, but we have not obtained.
No, notice to the respondent number 2.
Anyway, again, I'll take it, my lord, since LCR has come, my lord, I'll serve the extra copy. Can it be fixed on Wednesday?
No extra copies to whom? It has to be.
I'll give it to the PP. In the meantime, lordship can engage amicus curiae because, my lord, both sides are the laborers.
No, but the requirement of issuance of notice, you have to take steps.
I'll take it, my lord, now only, my lord.
Heard, Mr.
Fix on any day, very short day.
On the one hand, you are not taking steps. Heard, Mr. J.I. Bordhuya, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. Office note dated 23/7/25 shows that the scanned copy of the records which were called for have been received. Stop. However, it appears that the petitioner has not taken steps for issuance of notice upon respondent number 2 as directed by this court earlier. Learned counsel for the petitioner seeks some time to take steps as inadvertently the petitioner could not take steps as directed. The prayer is allowed. The petitioner shall take steps for issuance of notice to the upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within
Today, during course of time.
within 2 days. You can take within 2 days from
One
the
day, my lord, so that I can submit tomorrow morning.
1 day is always within 2 days.
Not-
I am giving you
I want, my lord, a very short days, my other co-accused has been enlarged on.
no, but you have to comply with the
Yes, yes.
notice within 2 days from the date of this order, returnable on.
Can you give short date, my lord? Because other person is out, my lord, and I'm also saying that.
Once it is submitted in registry, lordship, it takes 3 days time to reach our office. Lordship.
Can it be, my lord?
Then we are sending it by post, lordship. Then
Not post, by mail. You have to send it by mail. That is the requirement.
Yes.
7th of August.
Can it be 6th, man? 1 day.
Okay, 6.
Lordship.
Hello, here in this case, my lord, I am on ground of arrest, my lord. That my notice, my lord, under section 47 and 48, my lord. There is no ground of arrest, my lord. Your lordship may kindly take up the additional affidavit filed by the petitioner, my lord.
Also 61 and 62, lordship. Today it was fixed for submission of my
Written objection.
So, I am paying for 1 day accommodation, lordship, on Monday, lordship.
Let him file. He was given time. Heard Mr. S.M. Mullah, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor, who seeks some time to file written objection in this case as was directed earlier. The prayer is allowed. How much? When?
I will pay by Monday, lordship.
Tuesday. Let this case be listed again on 29th.
Same, lordship, same prayer, lordship.
62, same order.
Not, can it be up 30, lordship?
30. Earlier also 30.
Lordship, same queries are there, lordship,
Okay.
regarding ground of arrest.
30. Agor case to 30. This one is 30 kori diok. Yes. 30.
Much obliged, your lordship, much obliged.
Yes, there you are called for.
So CD not received, lordship.
You are an interim.
Yes.
Heard Mr. U. Dotto, learned counsel for the petitioner. Also heard Mr. K.K. Parash. Also heard Mr. P.S. Lakar, learned additional public prosecutor who seeks some time for producing the case diary. Prayer is allowed. Let this case be listed on when?
On 12, lordship.
On 12th of
Yeah.
August. The interim order shall continue till next day.
In both cases.
In
Okay.
41 and 42.
41.
Yes. No, dilute it. 41, 42.
Item 44.
Yeah, 44. Yes.
Wait, please, Lordship, conducting council is up. Can the matter be fixed on next week?
Yes. I'm very much.
It is
But
with-
you should have informed the PP before leaving. She was waiting. You should have informed.
The senior was also waiting, just few moments ago.
No, but
I was
before leaving,
My apologies for that one.
her-
Next week.
heard Mr.
ABC.
What is your name?
AB Singh.
AB Singh, Learned Counsel for the petitioner. Also heard Miss M. Kumari, Learned Special Public Prosecutor, CBI. Learned Counsel for the petitioner seeks an adjournment on the ground of personal difficulty of Learned Senior Conducting Counsel, Mr. M. K. Chaudhary. Considering the ground, the prayer is allowed. Let this case be listed again on 13th. 13th. The interim order shall continue till next day.
13th of August.
38 or
8th, 30.
30.
Oh, you choose a date, 13th of August. 13th, 13
August.
August.
13th of August.
Prior to that.
No, now you cannot choose. You have left without informing either court or your adversary.
Hurry, please.
Acha bhai.
Item 45.
None has appeared for the petitioner on call. List this matter on list this matter on a date to be fixed by registry.
Item 46. The petitioner has appeared. Could you have any scope?
You are on interim.
Yes, madam.
Heard Mr. P. Kotoki, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor, who has produced the case diary and has submitted that the petitioner has appeared before the investigating officer and has cooperated in the investigation. In view of the submissions made by the petition, Learned Additional Public Prosecutor, the interim bail granted to the petitioner by order dated 30/5/2025 is hereby made absolute.
Item 47. So just one, however, there are incriminating materials.
Let there be, you file charge sheet if there are intermittent.
Earlier interim granted in item.
What is have you appeared?
She's a lady lordship, she has appeared.
Item number?
47, Lord.
Heard Mr. P. K. Das, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor, who has produced the case diary and has submitted that the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of the submissions made by Learned Additional Public Prosecutor, the interim bail granted to the petitioner by order dated 4/6/2025 is hereby made absolute with condition number Roman 1 and Roman 2 attached to the said order remaining intact. Send back the case.
Deeply obliged. Is a lawsuit. The anticipatory bail application. Lawsuit will find the FIR as page 12.
Yes.
May I read, madam? Respected sir, most respectfully, I beg to state that I am a trader engaged in the distribution of transported fish. I have engaged a person by the name of Mufazzal Islam. Mufazzal Islam is the petitioner, madam.
son of so and so, resident of such and such place, as my manager to manage the daily affairs and accounts of the state business. On 13/5/2000.
Who are you?
I'm Mufazzal Islam, my lord.
Okay.
On 13/5/2025, my manager Mufazzal Islam called me over the phone at around 2:06 a.m. and informed me that on that night, in between 1 a.m. and 2 a.m., a band of dacoits had entered into my home at Borveti, and therein they had gagged Hibzur Ali, who was sleeping inside my house, tied up his hands and legs, and also blindfolded him. They beat him up, sprayed on his eyes, and thereafter they broke into my almirah and robbed rupees 11,56,000, which was kept in the almirah. Hibzur Ali is currently admitted in the ICU of Metro Hospital, Nagaon. On being informed so, I asked Mufazzal Islam to appraise the police authorities about the incident, and I proceeded to Hyderabad Police Outpost from Dimapur. Thereafter, police went and investigated into the matter. Yesterday, on 16/5/2025, when Hibzur Ali recovered completely, I questioned him and found out that my manager, Mufazzal Islam, had orchestrated the whole episode, and he himself tried Hibzur Ali and robbed the entire sum of 11,56,000 and tried to give the whole episode a color of robbery. So, as per the FIR, my lord, I was the mastermind. I had tied Hibzur Ali and then tried to project it as a case of robbery. Now, the Lordship will kindly come to page 20. Page
Yes.
20 is the seizure list, my lord. 1,89,000 rupees had been recovered by the police as led and showed by Hibzur, taken from the house of Ashia Khatun. Ashia Khatun is his mother-in-law. Now, this Hibzur Ali, who said that I had gagged him and I had committed the entire act, my lord. Now, he leads the police to recovery of a portion of the money. Now, my lord, this matter was on the last occasion when this matter was listed in the case, I was also there, my lord. Some arguments were also presented from both sides. What was projected, what has been projected from the prosecution side is that Hibzur Ali and the petitioner had both colluded and orchestrated the whole thing. And Hibzur Ali later revealed before the police that it was at my behest this was being done. And that is why this 1,89,000 is the amount of money which I had given him. And so he, with his help, this money was recovered. Now, one thing which I had submitted on the last occasion was, if Hibzur Ali was also part of this whole conspiracy to rob the money, then he is also in the status of an accused. But he has neither been arrested, despite the money being recovered on being led by him. He still remains a witness to this case. He has been made a witness to this case, my lord. He has not been made an approver. He remains. So, if he is a witness and he himself confesses that I was part of the whole act, then he is a witness there is no credibility to his account. And if he is an accused,
He may still be arrested.
He may be arrested, but as of now, when the police has arrested, that was, my lord, that is why the case diary was sent back for updation to see as to what action is taken by the IO.
Against Hibzur Ali.
Against Hibzur Ali. If he still remains a witness, he is a witness whose credibility is questionable. And if he is an accused, whether the police arrest him or not, that is the prerogative of the police, then the entire case against me is based on the statement of the co-accused. That is my submission. So now,
But at this stage,
yes,
at this stage of investigation,
even so, my lord, if he is a co-accused, then why should the police or why should this honorable court believe his account? If I am denying my role, he is admitting his role. So if he is admitting his role, then there is no reason for him to be believed, my lord. That is my submission.
My lord, yes, Hibzur Ali, Hibzur is the caretaker of the house. My lord, that informant owner was not there. The manager came and told him that I will pay you 3 lakhs. First given some money. He stated that as per his statement that 1,89,000. Even how much 500 note 100, that is also stated by the Hibzur. Total 189 rupees was given. Then by one vehicle of the petitioner, they went to a house of relative of the Hibzur and kept that money in that house and came back subsequently in the night. Accordingly, he tied up. He stated, now I will tie you and I will call some people. And subsequently, and they were by the people, they were taken to an hospital. And Dr. Malat didn't want to take him, and subsequently they approached another hospital and just taken in ICU. How ICU, I don't know, malab, injury report is not there, but subsequently when we regained, malab, he stated the whole story to the informant. Now we are not in trial, malab, we are in the initial stage of investigation in the, malab, considering the anticipatory bail, and he is, malab, absconding with rupees 11,56,000. So at this stage, malab, when investigation is there, malab, it is not a fixed case for malab anticipatory bail, malab, to the petitioner, malab, he is
Yes.
11,56,000.
I'm not absconding, my lord. I'm trying to have approach this court seeking the right which is available to me. Your lordship grants me or not, that's a different thing. So I've not absconded. The only limited submission.
The police is unable to arrest you.
I am.
You are not absconding.
I'm not absconding. I
But
have appeared before this.
Police is unable to
Unable
arrest.
to trace me. That much of, my lord, some safety measures will be taken by me. Otherwise, my lord,
Yes,
this becomes
yes,
infructuous.
yes.
The
But
only-
this is not a case where you will get an anticipatory bail.
Your lordship, my submission is that, my lord. No, I don't understand why the police is distinguishing between the two of us.
No, what police will do?
If Hifzur admits, because I am denying, Hifzur is admitting his role. No, my lord, what is stopping Hifzur from falsely implicating me? Because money was recovered from Hifzur. He led the police to recovery of the money. He claims that I had planned it. I am denying it. So nothing is stopping Hifzur from falsely implicating me. So when the person is admitting his role, and yet the offenses, the case has been
One line,
registered.
say
A case has also been registered under criminal breach of trust and theft. So what I am unable to understand is why the police is not taking any action against Hifzur and treating him as a witness and making me, and I am being projected as the main mastermind when the person is admitting his role.
Malab, I'm reading only two lines of the statement, long statement, malab. মোৰ হাত মুখ বান্ধি থব বুলি পৰিকল্পনা কৰে, তাৰ বিনিময়ত মোক 3 লাখ টকা দিব বুলি কয়। মুফাজুলে মোৰ কথা শুনি মই লগে লগে অমান্তি হলো, কিন্তু মুফাজুলে মাৰি পেলাম বুলি কোৱাত মই ভয়তে মান্তি হলো।
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, the additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Mufazzul Islam, who is apprehending his arrest in connection with Nagaon PS case number 403/2025 under section 61 within bracket 2/316 within bracket 4/303 within bracket 3(2) of BNS. The gist of accusation in this case is that on 17/5/2025, one Amirul Haq had lodged an FIR inter alia alleging that on 13/5/2025, he was informed by his manager, Mufazzul Islam, that some dacoits the present petitioner, who is the manager of the informant, that some dacoits entered into the house of the petitioner, house of the informant at Borbeti, and tied the legs and hands of Hifzur and looted an amount of rupees 11,56,000 from their stuff. However, it is also alleged in the FIR that later on the said Hifzur Ali informed that whole incident was orchestrated by the present petitioner, and he tied Hifzur Rahman and took 11,56,000 from there and gave it a color of robbery. Learned counsel for the petitioner has submitted that the petitioner is an innocent person and is in no way involved in the offense alleged in the FIR. He submits that from the seizure list, it appears that it was Hibzur Rahman who led the police to recovery of an amount of rupees 1,89,000. Stop. However, till date, said Hibzur Rahman has neither been arrested nor he has been shown as an accused in this case. He submits that why he is not believable.
It was Hibzur Rahman who had orchestrated the whole thing. And he, after being caught by the police, he took the police and led to the recovery of the money.
Learned counsel for the petitioner submits that the said Hibzur Rahman is now concocting facts to falsely implicate the present petitioner. He further submits that the petitioner is ready to cooperate in the investigation and therefore prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Noga PS case number 403/2025 and has submitted that there are sufficient materials in the case diary which indicate to the complicity of the present petitioner in the alleged offense. And he further submits that the investigation is still at initial stage and therefore at this stage the petitioner may not be allowed to go on anticipatory bail as there are incriminating materials against him. I have considered the submissions made by learned counsel for both these sides and have gone through the case diary of Noga PS case number 403/2025. Stop. At this stage of the investigation, materials which indicates to the complicity of the petitioner in the alleged offense. Hence, this court is not inclined to grant the benefit of order under 482 to the petition 482 BNS to the petitioner at this stage. The prayer for anticipation rejected.
My lord, I was on interim order is 9/6/2025. Thereafter, I have appeared before the investigating officer. My lord.
Heard, Mr. What is the name?
S. Hazarika.
S. Hajorika, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
159/2025 dated 22/7/25.
Considering the learned counsel for the petitioner submits that the petitioner has been granted interim anticipatory bail by this court on 9/6/2025 with certain conditions, and petitioners of a plural, and the petitioners have cooperated in the investigation. So, considering the submissions made by learned counsel for the petitioner and considering the fact that the charge sheet has already been laid, the interim anticipatory bail granted to the above named petitioners by order dated 9/6/2025 by this court is hereby made absolute. With condition number 1 and 2 attached to the said order remaining intact.
I'm deeply aware.
Mention item number 59. My lord has fixed the matter for today. Problem is that I'm the teacher. In my absence, since I'm running from that very day, I'm also the DDO, headmaster, and I want to take part in investigation. Kindly protect me or give me 3 days time so that I can do the formalities, because for me, another 18 people are suffering. I want to take the moment if your lordship pass me to today's order, I'll be appearing today, sir.
No, time is over.
My lord, the thing is that your lordship, try to understand I've got only 4 months of left service. I want to cooperate. So nothing is left.
Case diary is there.
No,
Not there.
Case diary, why it is not there?
It did not, it has come up for orders, lordship.
Yeah, orders because of the IAM.
My lord, may kindly look.
But it was fixed today for case diary.
Yes, it is not.
Kindly protect me. Kindly, I want to take part, because if I appear, at least I can put signature in my office so that another 18 people can get.
But you may misuse your liberty.
Stringent condition be imposed. And if your lordship wants, on the next day, I will be present here in this court. If your lordship doesn't find anything, I will surrender. Let it be recorded. Let it be recorded in the order. Absolutely, it's a POSCO case. So I want to take part.
Where is the
Kindly see your order, your lordship.
No, I'm not. I have heard your submissions. I have go through the records.
Your lordship, my problem is there. I have got 4 months of service. Your lordship, what is the harm in the case of the prosecution? I want to cooperate. If I don't cooperate, if I don't appear, that's a different thing. I'm going to appear so that on Monday I can sign their checkbooks. At least those 18 people can get their salaries. What is the harm in it? And if I don't make out a case, on the next day your lordship will cancel it. Of course, notice. Let it be recorded. Interim protection, my lord. I want to take part.
Fixed on Monday. I want to hear the matter because there are some lacunas. You have not made respondent.
Your lordship, I bow down to that. If your lordship is fixing on Monday, let him be asked for a case diary.
Yes.
Because otherwise,
You inform telephonically for the PP for.
Interim, I'm asking.
And no, direction is for issuance of notice.
Yes.
Already direction has
We
been.
have taken the step.
Item number
59.
59.
We have already taken.
This matter could not be taken up due to paucity of time. Let it be listed again on 28/7/2025.
Top of the list.
No.
I don't want to go to the same fate. Otherwise, it will come in the order column only.
If
at least 2 people.
Why it is in order column?
Because of that application, my lord, which we filed for implementing the
IA because.
But you have taken steps.
We have taken the steps, my lord. So that's why the IA came up.
I am allowing today.
My lord.
And
your lordship may kindly permit me at least for those 18 people.
No.
Let it be on Monday, my lord.
Yes, on Monday.
Let it be on Monday.
And
your lordship,
an additional public prosecutor is requested to telephonically inform the investigating officer for sending the case diary by the next date. Monday.
Always.
That's item 50. Case diary is it's your notes. 50 CD is there. 56 ones. 51, 54,
I have 64.
15 also, they have 84 CD are there, some are in interim.
4 case diaries are there.
50 they have appeal also recorded their statement.
You are on interim bail.
Yes, sir.
Don't be in rush. Interim bail, we will exchange. We'll fix it on.
CD may be repealed. Therefore, I am making.
Yes.
Let's say item 56, CD is there already, and I am praying for the anticipatory video.
No, we will not take up matters now. No matters.
Registry will
If CD is there, it is, let it be on Monday.
On, I don't know, 50, on first of August.
50, we may, it will be on 4th. Case diary will be written 50 Munmun on 4th.
Okay.
4th.
I'm for the item 64, my lord. Same to 64 item.
Interim shall continue.
It is available, my lord.
Wherever CD is there, 4th. Rest, the registry will give dates.
see the numbers.
Item number 53.
Yes.
It may be listed in the next week.
No, registry, it will be shown as leftover.
Lordship, I beg to mention 55. I am interim deadline.
Where there is interim, there is no urgency.
Lord.
Don't make mention.
Lordship, 56 on Monday.
Monday.
If it was 64, then we have 64.